May we also have the national anthem on cue? Please let me know when that is ready.
Discrepancies.
May I request that the The caterers, please help us make this really snappy. We're running behind time. Can we make this as fast as possible? We have a full day today. Ladies and gentlemen, please may I request that if you're sitting behind and you have an empty table in front of you, kindly fill it up. Let's try and get the whole arranged so that once we start, we don't have those coming in late, distracting the sessions. Ushers, help me with this, please. Please help us. Please just help us fill the tables in front of you. Thank you. Thank you. All right. Please, may we all be settled? May we all settle in, please? We're about to start. Thank you, ladies and gentlemen. Please, may we go back to our seats as we're about to take the national anthem. May I have the national anthem on cue? Thank you. Please, if you're just coming in, kindly take your seats. Thank you. Ushers, could you please direct them to where they'll be seated? Could you put them on their tables? All right. May we all rise for the national anthem. Servers, wherever you are, please stop. May we all rise for the national anthem. Let the servants stop, please. After the anthem, you can continue. Thank you. may be seated. The President BRIPAN, Milords, honorable judges and justices here present, the Vice President, the First Deputy Vice President, the Second Deputy Vice President, the General Secretary, the Treasurer, the Council members, EXCO members, Members Planning Committee, distinguished ladies and gentlemen, gentlemen of the press. You're welcome to day 2 of the BRIPAN International Conference 2023. Please put your hands together for yourselves. I'm sure you agree with me that yesterday was exactly how we had imagined it would be, or maybe even better. And it was such a beautiful time, such an insightful time. We had very interesting, thought-provoking discussions and sessions, and of course we're looking forward to today. Yesterday we had a lot of people who wanted to ask questions, but because we were short of time, we couldn't take a lot of questions, and so we really would like to kick off very early today so that we can have time to really interact, take as much questions as possible, and really just squeeze and juice out all we can from today. All right, I'm so excited. I'm not just excited because we're going to have a very fantastic session where we're going to be talking and with a panel, but I'm also very excited because tonight there's going to be a party, if you know what I mean. Permit me, my lords. I know we're all very serious people and most of us here don't like to party, but I like to party. Oh my goodness. And so later tonight we're having the gala night. We're going to have DJ, we're going to have music, we're going to have lots to eat and drinks, and of course we're not going to have jackets on and ties on, you know what I mean. We're going to have our dancing shows. It's a themed party, yeah, and so I think it's Afrofuturism. So it's going to have a touch of our African ethnic culture, our rich, beautiful heritage, and we're going to go down low. All right, but ladies and gentlemen, back to being serious. So yesterday we had really interesting discussions. You know, there are people that when they go to church and they come back from church, I don't know, Madam Treasurer, I don't know if you know those kind of people. You ask them, how was service? They say, service was powerful. What did they say? It was wonderful. What exactly was discussed? What was the topic? It was just, the glory. What was said, you don't know. But you just know it was powerful. But I'm trusting that there are people in this room. The people in this room are not those kind of people. And so, yes, of course, we had takeaways from yesterday. If I would ask my ushers to kindly help me real quick. We're just going to do a bit of a recap from yesterday. In 1 minute, just go around. Feel free, no look face or no fear anybody. Give anybody the microphone and they'll drop what they took away from yesterday. The high points for them from yesterday. Anybody at all? All right, sir.
Hello?
Yes, it's on.
I think the highlight for me was talking about the hostility in receivership by Dr. Kemi Pinero, which is quite interesting. Having to present yourself before the IG, and it's something we've dealt with for years, and we have still not been able to move away from it. So I think there needs to be a collective action to be able to stand on that. And obviously, bear in mind our client's ultimate instruction, which is to, as much as possible, get them a positive result. Yes, still balancing our own legal interest and also prestige and integrity as well.
Fantastic. Please collect my mic. Before you know it now, this man will climb up here and take my job. I have to be careful. Please, mind who you give that microphone to. Go to that table. I see some beautiful ladies there. I'd like to have one. Were you here yesterday? Come. See where my money go come out from. My sister give her a microphone. I don't want to lose my job. Give my chairman the microphone.
Okay, thank you very much. For me, the highlight is the fact that we considered the Nigerian debt profile, and the fact that we're even thinking that Nigeria may be insolvent is something that we all have to be thinking about. But of course, we heard from the speaker the fact that our problem is not really the quantum of debt, but the fact that we have revenue problem, and the fact that there's a need to harmonize the debt profile management and the revenue generation management. And I think that is a major thing that I want to take away. And I believe that all of us are thinking about it. Thank you very much.
Thank you so much, sir. Please, can you hand the microphone over to my boss, Madam Treasurer?
Okay, thank you. Yesterday, we learned that even Nigeria needs restructuring. And it seems Nigeria itself is insolvent. And our attitude and practice of insolvency should be geared towards helping Nigeria to be restructured back to what it should be. Thank you.
Thank you so much. At this point in time, I'd like to ask Dr. Kubi. Dr. Kubi, could you please help me here? Now, Dr. Kubi is going to help us with a wrap-up. For those of us who were not here yesterday, you missed out, but not to worry. With this review, I'm sure you'll be able to catch up just a little bit. But we're streaming live, and as such, I know you can get to do a preview after now. Please hand the microphone over to my doctor. You're welcome.
Thank you. Good morning, distinguished ladies and gentlemen. Please permit me to stand on already established protocols. So yesterday we had a fantastic time at the conference here. For those of you who were here, we had 2 sessions, several topics dealt with during those sessions. So I'll just take us through some of the topics and the sessions we had yesterday for the benefit of those of us that were not here and those of us that may have... Okay, thank you. Those of us that may have forgotten. All right, so the first session... Sorry about that. I thought I was audible. All right, so the first session was themed Insolvency and Restructuring as Catalyst for Economic Growth and was ably chaired by our former president, Chief Anthony Idibe SAN, INSO Fellow. And under that session, we dealt with 4 different topics but interrelated topics. They included effective strategies for restructuring Nigeria's soaring debt. That was taken by Dr. Chinyere Almona, who was ably represented. We also dealt with salient issues in sovereign debt management with focus on Nigeria. Was dealt by a representative from the Nigerian Economic Summit Group, Dr. Olusegun Omisakin. We also looked at optimizing Nigeria's insolvency and restructuring law as a tool for economic growth. Was dealt by an international expert, Dr. Aurelio Martinez from the Singapore Management University. And we wrapped up the day by looking at opportunities and challenges for insolvency practitioners under the African continental free trade area. And that was taken by no less a personality than our own Mr. George Etomi, Mr. AFTA. So we had a break and then we had the second session, which focused squarely on market insights. And of course, like the first topic, we had different interrelated topics under market insights. The session was ably chaired by Mr. Olawale Akoni, the managing partner, SAN, the managing partner, Babalakin & Co. And the first topic that was dealt with in that session was the role of the judiciary in promoting sustainable corporate rescue culture in Nigeria. That topic was dealt by Honorable Justice Ebiwoyi Toby, who was ably represented by Honorable Justice Osiago. And then we also had the topic on, like someone highlighted earlier on, hostilities in receiverships. And we asked ourselves whether it's time to have reforms, given the resistance insolvency practitioners face in receiverships and the perception that people have about receiverships as sometimes being very violent, that you have to employ the police or security agencies to be able to enforce court orders. So that topic was ably dealt with by a seasoned professional in the person of Dr. Oluwakemi Pinheiro, Senior Advocate of Nigeria. Thereafter, we looked at the failure of microfinance banks in Nigeria, causes and panacea. Of course, you would agree in the past couple of years, every now and then you see a list published by the Central Bank of Nigeria announcing that banks, the licenses, microfinance banks, licenses have been revoked, and NDIC calling investors or depositors to come and make claims. I think last year we had about 137 of them or thereabouts. So it was important we squarely deal with this topic, not just looking at the causes for incessant failure of microfinance banks, but also looking at the panacea solutions to this incessant problem. And this topic was handled by Mr. Kofo Salam Alada, the legal advisor and head of legal services, Central Bank of Nigeria. The last topic under the second session for day one was a look at the NDIC Act 2023, and we tried to focus on insolvency and implications for insolvency and resolution of banks in Nigeria. And this topic was dealt by the Director Legal Services, NDIC, Mr. Henry Former. So we wrapped up the day with that topic, and I must say we had a very rewarding day. It was very insightful. We took questions and answers. Unfortunately, there wasn't enough time for your questions and answers, and like I appealed to so many people that came around to meet us afterwards, you could still send the questions. I was able to get cards of some of our resource persons because they were willing to share their cards. I mean, we're all professional colleagues. So if you have questions regarding some of the issues that were discussed, I was able to get their cards to give those that are interested. And so the conversation continues. If you weren't able to ask questions yesterday or you were too shy, to come forward to ask the question, you could easily approach me. I would pass some of those contacts to you, or you could pass the questions to me and we'll channel it to the right or appropriate sources. So that was it for yesterday, and I believe today we are going to have even a more rewarding sessions by God's grace. Thank you very much.
Please, may we put our hands together for Dr. Kubi for such a fantastic delivery there. All right now we go straight into the session for today. It's day 2, and for our first session, we'll be looking at cross-discipline and cross-border practice. And the coordinators for this session, we have the very handsome, very brilliant Richmond Ideho, ABR, Senior Associate Jackson Ete and Edu. And we have Chika, the beautiful Chika Madneme, ABR, Senior Associate Indemnity Partners. Please put your hands together for them as they take on the podium.
A very good morning to you all. Good morning, distinguished ladies and gentlemen. I welcome you to the most interesting section of this BRIPAN 2023 conference. The topic of this section is cross-border discipline and cross-border practice. To chair the section, we have Ms. Oluwasheo Mamoe. A round of applause for her, please. She's partner and the chief operating officer at T Group. T Group are our diamond sponsors. A round of applause for T Group, please. For the panelists, we have Mr. Amala Omeke. Mr. Amala Omeke is the founding partner, Strain and Blend Partners, our gold sponsors. A round of applause for them, please. He will be taking on the topic Ponzi schemes, fraud and asset recovery, civil and criminal toolkits. So this is just a bonus for those of us that have an axe to grind with so-called investment companies, please pay attention to Mr. Mala. He will show you how to go about it. Mr. Mala, glad to have you here.
Good morning, everyone. So, our other speakers, all the way from the United Kingdom, we have Mr. Richard Haley. Mr. Haley is a partner and head of dispute resolution, Gately Legal. He is also a board member, Gately PLC. He will be speaking on the topic, the use of insolvency for cross-border asset recovery, a case study. Our other panelist, who is joining us virtually, is Ms. Samira Musayeva. She is the Senior Legal Officer, OSICRO Secretariat, and Secretary, OSICRO Working Group 5 on Insolvency Law. She'll be speaking on the topic, OSICRO Modern Law on Cross-Border Insolvency, Framework, Opportunities, and Drawbacks. Please, a round of applause for Ms. Samira Musayeva. Our other speaker, Mr. Roger Steri Turasingura. He is equally joining us virtually. He is the Senior Legal Consultant, Anderson, United Arab Emirates. He will be speaking on the topic, Insolvency and Restructuring in the Digital Age, Challenges and Prospects. Please, a round of applause for Mr. Suring. Thank you very much.
So on a final note, allow me mention that Gately Legal is a diamond sponsor. A round of applause for them, please.
Good morning, everybody, once again. Ladies and gentlemen, esteemed guests, and our distinguished panelists. You're welcome to this session. As earlier mentioned, we'll be discussing cross-discipline and cross-border practices as it relates to insolvency and restructuring law in Nigeria. Our objective for this session is to be able to explore the dynamic intersections of cross-discipline and cross-border practices within the concept of insolvency. It's a multifaceted topic, and I am confident that our panelists will do justice to it and be able to provide insight to the different segments of the topic. Each of our panelists will have 20 minutes to speak. While they are speaking, please, you can write down your questions if you have questions for them, so that after the 80 minutes, we have a little time for questions and interactions. I would enjoin our panelists to please stick to time so that we have enough time to take people's questions and we can interact more. Without wasting time, we are going to start with Mr. Richard Healy. He's going to be discussing the use of insolvency for cross-border asset recovery, focusing on the English jurisdiction as a useful tool for Nigerian insolvency practitioners. A round of applause for him, please.
Hi, good morning, everybody. Can I first thank you for the opportunity to speak here today? I'm absolutely delighted to be here in Nigeria. This is my second visit to Nigeria, and I have to say, it's absolutely fantastic, and I couldn't have been treated better. So thank you very much for this opportunity. I am not going to talk to you about insolvency here in Nigeria today, not least because you guys are the experts in Nigerian insolvency and you know far more about it than I will ever know, and so I'm just not going to go there. I'm actually very honoured to be here speaking with such distinguished speakers here today, and I almost don't feel worthy that I've never seen so many doctorates and leading academics and KCs in one gathering. So I'm absolutely delighted to do this. What maybe does qualify me to be able to speak about some of these things is 25 years experience of operating in London in the context of cross-border insolvency, asset recovery, particularly involving aspects of fraud. So there was discussion yesterday about turnaround of businesses and how there shouldn't be stigma for insolvency failure. I don't really get involved in those cases where there's been an innocent failure. My background and my practice is dealing with the fraudulent and those that deliberately contrive insolvency. They strip out all the assets and they hide those assets around the world. I, for the last 25 years, have worked with, particularly with governments, with banks, with insolvency practitioners, to deal with those situations where you have a group of individuals, whether they're the shareholders, whether they're the directors, whether it's sometimes the controlling family, who systematically go about a situation of contriving an insolvency with the aim of stripping out the money, hiding it around the world, often in offshore jurisdictions, often in places where the money shouldn't potentially be. It's secreted in things like trusts. It's put into a myriad of offshore companies, and then often ends up, sadly, in jurisdictions like mine, like London, where it's invested in real estate and it's effectively laundered. It is often thought by insolvency practitioners, governments and other institutions that actually it becomes too difficult to get those monies back. What I'm here to talk about today is the fact that actually, with the right case and the right situation, it is very possible to get those monies back and actually to make significant returns to creditors. So with that in mind, I wonder if I can have the first slide, please. Are we good with the slides? This is going to be one of those horrible moments, isn't it, where I'm going to have to improvise without the slides. Well, the good news is, guys, I'm not going to sing. Yeah. Okay, so let me talk you through the slides and what we were looking to talk about. So, cross-border. So, in terms of why is it of interest to you insolvency practitioners and other professionals here in Nigeria to consider the UK as a potential jurisdiction to look at pursuing, next slide please, cross-border insolvency? Well, the answer to that is because London is often the destination where the monies end up. And we have a history of, with emerging market countries, with debtors or guarantors who leave their home jurisdiction and skip off to London and effectively seek to hide themselves in London, investing the profits of their ill-gotten gains in real estate. I, for the last 20 years or so, have operated in emerging market countries, in places like Ukraine, Central Asia, Russia, where you have just those sorts of situations. People enter into large banking finance arrangements, or indeed in some cases they even run a bank, and they transfer the monies out, usually via places like the British Virgin Islands and Cyprus, and those monies end up ultimately in London. So too does the the debtor or the guarantor. This is becoming increasingly of interest for Nigeria, as evidenced by the fact that there was a 93% increase last year in the amount of claims being brought in London by Nigerian claimants. And so, just thinking about that, that is claimants who are based in Nigeria who have pursued a debtor or a defendant to London. So the ability to do this and to pursue these methods can be additive to your insolvency. It's not the British or the English practitioners there to take work away from you local practitioners. It's actually to assist you to facilitate recoveries for creditors and work on your behalf. So, what I'm actually going to talk about is firstly, cross-border insolvency regulations. Secondly, how the English courts approach these things. And thirdly, recent judgments and the limits imposed upon the ability to do cross-border insolvency based on those judgments. Next slide, please. So, purpose of the UNCITRAL model law for these purposes. And yes, I know that as yet Nigeria hasn't adopted the UNCITRAL model law, although I understand discussions are ongoing in that regard. But the fact that Nigeria is not a nation that has adopted the UNCITRAL model law makes no difference to your access and your ability to access the English courts using the UNCITRAL model law. So, what's your way to do that? Your way to do that is by use of the cross-border insolvency regulations 2006, which was the UK's enactment of the model law. So, let's think about this scenario. You've got a large insolvency here in Nigeria, potentially involving fraudulent activity, or if not fraudulent activity, certainly large debts, and perhaps either your debtor or guarantor has skipped off to London, or you may be aware that there are potentially significant assets belonging to your insolvent estate that are located in London or the UK. Either mechanism would give you access to the UK courts, relying upon the cross-border insolvency regulations. There would need to be an application made for recognition, but frankly, subject to a few things I'm going to say in a moment, those applications are relatively straightforward. Once you make that application, there'll be a consideration as to whether or not you are making it on behalf of the main proceedings. So if the insolvency has been started in Nigeria, then the question is, then are they the main proceedings? If they are, then there'll be a relevant consideration as to where the centre of main interest is. And whether or not they are main proceedings will affect the scope of the recognition by the English court. Next slide, please. So, under the cross-border insolvency regulations, under Article 21, A21, if you have made, as the insolvency practitioner here in Nigeria, an application to recognise your Nigerian insolvency in London, the immediate effect of that application is to stop any enforcement action that may be being brought against the debtor in the UK. So, just thinking that through, let's assume that you have a debtor who's skipped off to the UK, you know that he or she has significant assets, but perhaps, for example, that they have creditors also in the UK that are seeking to take enforcement action. Subject to certain exceptions, the effect of recognition will prevent any further action being brought at that stage by the UK creditor. And the purpose of that is to seek to ensure that there is a pooling of the assets and that there is parity between creditors, to not allow effectively one set of creditors to get a head start on the other. Similarly, if you get recognition, you can then use certain investigatory powers to examine witnesses, to try and understand a little bit more about the debtor's assets, about the debtor's affairs, to understand effectively what money or what property or other interests he or she may have. You can compel those witnesses to come to court and give evidence on oath, and if they fail to do that, then you can effectively you can seek an order committing them to prison for contempt. So these are very powerful remedies. You can also seek those powers that would be available to you under Nigerian legislation to be granted to you to exercise in the UK, provided in some way that they are not incompatible with British law and rules of public policy. Next slide, please. So, let's assume you get your recognition in the UK that you would have been requesting. What powers does that give you? Well, it gives you those same powers that would be available by and large to an English insolvency practitioner. So you will have the power to effectively pursue void and voidable antecedent transactions. So, for example, if the debtor has sought to give away his property or has tried to prefer one set of creditors over another, then you will have the power under the English Insolvency Act to recover those assets. So what typically happens in those sorts of situations is insolvency will be started in the home jurisdiction, so let's say for these purposes Nigeria, at which stage the debtor based over in the UK decides that he really, really wants to give everything to his wife. He loves her so much that in return for love and affection, and that's often what's stated in the contract, in return for love and affection, he wishes to transfer all his worldly goods to his spouse. In those situations, that would be a transaction at an undervalue, and indeed potentially a transaction defrauding creditors. And that's clearly, we would say, been entered into to try and place assets beyond the reach of you as the Nigerian insolvency practitioner for the benefit of creditors. Under the English legislation and following your recognition, you would have the power to reverse that transaction by making an application to the court. Similarly, if the individual's preferred one set of creditors over another, i.e. he's decided to repay debts that he had to his family, rather than repaying the Nigerian creditors, again, that would be the sort of transaction you could reverse. Next slide, please. So, these are some of my favourite parts of the powers that are given. So what you can also ask the court for are the investigatory powers. Now, I'm not going to stray into talking about asset tracing here because I know that Mr. Omike is going to talk to you about that, and I don't want to tread on his toes. But one of the things that we often use in the UK insolvencies are what we call the investigatory powers. So those are in the context of a liquidation enshrined in sections 234 through to 236 of the Insolvency Act. With a personal insolvency, with a bankruptcy, they're under Section 366. Section 234 enables you to seek any documents that may be held by a third party that relate to a company's affairs. So let's assume that you here are liquidators of a company that is based in Nigeria. Your debtor or the director has gone off to the UK. He has accountants or auditors or lawyers that may be based in London who act for the company. You can use Section 234 to get hold of the auditor's papers, the banking records in the UK, the lawyer's records, and they cannot assert privilege because the privilege belongs to you representing the company as the insolvency practitioner. Similarly, you can use Section 235 to call any individual that may have information about the company's business dealings or affairs into court to give evidence on oath about any aspect of the company's business that you wish to ask them about. If they refuse, again, you can have them committed for contempt. So what we will traditionally do in these sort of situations is, often there are very few records. You will use these powers to reconstruct the records, and so that will give you a mechanism to be able to see what are the bank statements showing, where has the money flowed from, where has it gone, who's it been transferred to. So again, these are powerful. Next slide, please. So why do we even think about London as a possible place to go for these sort of things? As I say, it tends to be, sadly, London tends to be the refuge quite often for the proceeds of these frauds. You will all know that we have a long history of at the moment, Russian money that's flowed into the UK, and I have been involved in some of the largest insolvencies emanating out of Russia, where we've pursued remedies against the debtors back in London. It's important to remember that the cross-border insolvency regulations are not a mechanism for enforcing judgments. That was in fact confirmed by the courts quite recently, and so again, it's important to know that that's not how it works. Next slide, please. Again, coming to London, if you decide then to bring recovery proceedings in London, you have the availability of a whole host of remedies that wouldn't normally be available to you. Well, it's certainly in civil jurisdictions. I appreciate here in Nigeria you operate under the common law, and so therefore some of these remedies will be familiar to you, but you will be aware that if you bring proceedings in London, you have the ability to seek a worldwide freezing order, you can appoint a receiver to pursue and get hold of assets pending the determination of claims. You have the ability to exercise what we call search and seize orders, which are very powerful orders which enable you to go to the debtor's property, to search their premises under the supervision of a solicitor, and to take away information. So, as I say, there is a set of tools that are available in these London proceedings that often are extremely powerful at gathering evidence. The other thing to bear in mind is, I'm very aware that London litigation has a reputation for being expensive. I would, of course, say it was best value, but I am very conscious that there have been some very high-profile, very expensive cases. Please bear in mind that particularly for large-scale insolvencies, there's a big appetite in London now to bring in forms of litigation funding. I myself and my own firm, we provide litigation funding as part of those services we offer. The cases have to be large enough to support it, but ultimately it is possible to bring in funds which can be used to pay the local lawyers here, the local insolvency practitioners, and can also then meet the cost of the English litigation. So again, another reason to think about not just considering London to be the end of the story. Next slide, please. Again, tools that are available, very extensive disclosure powers. So the ability to call for all adverse material, to seek specific disclosure from parties, targeted disclosure. I'm involved in a very large case at the moment for the Ukrainian government, which spans 4 different jurisdictions, where ultimately we know that the defendants have some information that they really, really don't want to disclose. And if you put enough pressure on and you keep going back to court and you are focused in your disclosure requests, you can make life very, very difficult for your opponents. So again, the UK is very strong on its disclosure. Next slide, please. Again, courts are now taking a much more active role in the administration of the trial process. They are acutely aware of managing costs and making sure that actually access to justice is being properly delivered, particularly on insolvency cases, because, again, we are aware that ultimately creditors have lost money and there's a desire and a need to try and return money to those creditors. Next slide, please. So, there are limits to this disclosure. There are limits to the ability to use the cross-border insolvency regulations. So, this is no longer quite as relevant now because the UK is no longer a signatory to the Lugano Convention because we were thrown out because of our decision to Brexit. But I actually have the lead case post-Brexit on the limits of the UK jurisdiction. So the courts will look at to make sure that there is a proper nexus between the debtor defendant and the potential causes of action and the claim in the UK, and they'll consider quite carefully any arguments of forum non-convenience. Again, the rule in Gibbs. So I talked to you before about the fact that ultimately it is possible to put a stay on any enforcement action brought by a UK creditor once you apply for recognition. That is the case, but you cannot ultimately stay where, for example, a creditor has been granted valid security in the UK and is exercising its rights under its security. That was determined in the ruling Gibbs. And finally, in the context of transactions defrauding creditors, the UK court, just because a party was facing litigation, it doesn't automatically follow that any transfer will be a transaction defrauding creditors. The court will look at all the circumstances. So, that's broadly what I'm here to talk to you about today in this context. As I say, this is not intended to be instead of the role that you're doing. It's often just an added tool. So a number of the cases I'm acting on, I am just one part of a multi-jurisdictional strategy whereby we might have recognition in Ukraine or Kazakhstan, but then also in the US, in the UK, and Cyprus. And what we then do is we use the powers in each of those jurisdictions to gather the various forms of information. So it's just something for you to bear in mind and think about if you have any fraudulent insolvency cases or even larger insolvency cases where there is a UK angle. Thank you very much.
Thank you very much, Mr. Richard. Thank you for taking us through the cooperation of the English courts when it comes to insolvency cases. As long as we are able to follow the regulations, I mean the insolvency practitioners are able to follow the regulations laid down for that. I hope we have our questions written down. At the end of the entire session, we'll be able to ask him our questions so that we can quickly go into the second topic. The next topic we are going to be looking at is Ponzi schemes, fraud and asset recovery, the civil and criminal toolkit. Our speaker for this is Mr. Amala Umueke. Because he has to leave almost immediately after the presentation, we'll allow questions after he finishes his own presentation. So you can just write your questions down as in speaking. Once he's done, we take those questions in a few minutes, and then he can leave, and we can move to the next speaker. Mr. Amala, the floor is yours.
Thank you very much. If I'm allowed to sit, right? Thank you. It's a pleasure to be here. Thank you to BRIPAN for extending the invitation to speak on this. What I'm going to do is to speak on a niche area of fraud, so to speak, right? Richard has taken us through the English route, but we would be looking at perhaps an aspect of fraud that is a bit niche, and that would be on Ponzi schemes. And then we'll be looking at what are the typical civil and criminal tools and kits that can be used to tackle the menace of Ponzi schemes. Typically, if you look at the introduction or a definition of Ponzi schemes, it will tell you that, oh, these are investment schemes that would always have that appetite to give you high rates. When I ask myself, and I say all these things advisedly, nowadays, with the level of sophistication that we've seen in the market when it comes to Ponzi schemes, you would have to be careful, right? Because it's no longer about those schemes that offer high rates, but generally, such schemes that are unregulated, right? Because the level of sophistication we've seen in the market is such that they may no longer offer you high rates, but still, at the end of the day, these schemes would still be classified as Ponzi schemes, right? So even when we still define it as the investment schemes that will typically offer you high rates, you find that even legitimate businesses would sometimes pivot into Ponzi schemes, and we'll go into that. So essentially, it's the proverbial robbing Peter to pay Paul, right? Where you have a system where old investors are paid with monies from new investors, right? And then on and on until the well dries up, so to speak, and people then are left hanging. So that is essentially what a Ponzi scheme would be, right? If you look at the origin, it started in Germany and in the US, but the popular one that I guess everyone knows is the Charles Ponzi scheme that happened in the US, and that's where some of these things were popularized. What I've done is to give an example of some of the ones that I know is popular. I'm sure most of us here, nobody will admit that they invested in MMM, right? I'm sure nobody will admit that, but that was something that wiped up people's savings. One of the biggest ones currently ongoing is the Chimmark case. Fortunately, the provisional liquidator is here for the Chimmark case. And my very good friend, Carlo Correa, were acting on the same matter in that case. But, these are some of the known Ponzi schemes that have gone on, right? I'm very careful when it comes to saying there are ways that one can identify Ponzi schemes. And the reason is, as the market grows, and when I mean the market, that's the financial market, you see some level of sophistication being infused into this, right? So I guess people will still fall for high return. I mean, to a same mind, anybody telling you that you're going to get 50% ROI on an investment in a month, for instance, I mean, you would know that there is something wrong about it, right? So what they've done is to pivot to and then bring down these ROIs, but it's still a Ponzi scheme. So again, I warn myself when I say a guaranteed return or a guaranteed promise of high returns with little risk. You no longer see that in the market, right? I know of a particular fund, sophisticated, run by a sophisticated individual. You would never guess that this is a Ponzi scheme, but it's actually a Ponzi scheme. So to my mind, when I then think about it, I always say that at least if a fund is not regulated, right? If it's not registered with the regulators, which would be the Securities and Exchange Commission, right? Then run away from it. It's a Ponzi scheme. At least classify it as a Ponzi scheme. Those are some of the things. But, the usual thing is that there is high return on investment. It's not registered with SEC, and you then find out that there is little disclosure requirements, right? Those are some of the indices and indications of a Ponzi scheme. Again, what you then find is that for Ponzi schemes, right? And that's why when I started, I said it's a niche area of fraud, because it's actually fraud. The typical Ponzi scheme is started by a promoter who knows that at the end of the day, he's going to abscond with the funds contributed by investors. So at the base of that is the fact that he knows that at the end of the day, he's not going to pay back these monies to them. And so what we've seen then happen in the market is that when this first set of investors starts making contributions, they start moving the assets offshore, right? So we are acting in respect of one of the biggest schemes currently, where when we started the asset tracing, we then discovered that some of the assets had already been moved to an offshore jurisdiction. So it's clear at the beginning of the scheme that, look, I know what I'm doing. It's not a matter of, oh, this was an investment gone bad. This is a clear-cut heist. So there is always a cross-border nowadays when you look at it, and that's because I'm talking to practitioners who may act on some of these schemes, right, as insolvency practitioners. When you want to do your asset tracing, right, always look offshore. Perhaps after, I wouldn't want to say certain things here, but I can give you tips on some of the choice offshore jurisdictions where they hide some of these assets. So gone are the days when you do the asset tracing, because when I talk to some of the liquidators and when we act on them, I say, forget about Nigeria. These guys already know that Nigeria is not a safe haven. So what they do is to then hide some of these assets abroad. And they are not going to hide it in England. For very big, sophisticated fraud cases, you will find the assets in England. But more often than not, what we've seen them do is to hide some of these assets in some of these offshore jurisdictions, right? So, and this would be to our practitioners, always look offshore when you are doing your asset tracing for Ponzi schemes, right? Now, there's a dynamics to these Ponzi schemes, and that would be where a business started off legitimately, right? And we've seen that happen. A legitimate business model, right? Going on, and then perhaps out of malfeasance of the promoters or perhaps a bad economic turn, they then pivot that business from a legitimate scheme, from a legitimate fund, and then make it a Ponzi scheme. So, when I talk to some of the investors, and they tell me that, look, when they started these investments, this was not how it was for them. And so that's why I don't blame people who are victims of Ponzi schemes. Yes, there are some that obviously it would turn out that it was greed on the part of investors that led them into the problem. But in some instances, you will find out that it might not even be greed. It might be that the business or the fund started up as a legitimate fund and then pivoted into a Ponzi scheme. So we need to be careful about how we do some of these investments. And that is why it's important when you are investing in a fund to ensure that you follow the trends within that fund and demand for full disclosure. Again, in Nigeria, there are strict regulations when it comes to funds, and under the Investments and Securities Act and under our BOFIA 2020, there are regulations pertaining to registration of such funds. And so it's illegal for one to be able to operate a fund without proper registration in Nigeria. So again, for me, the test is if it's not registered, then it's a Ponzi scheme. Obviously, there are criminal liabilities when you do not register some of these investment funds. Now, to the one that I know would interest the practitioners who are seated in this room would be what are the tools and kits. The English Supreme Court had been able to water down what we have under the common law on illegal contracts, and they've put a public policy perspective to it, such that, yes, for sophisticated investors, you should have known that this is an illegal venture. But for those who would have invested their 2,000 naira, their 5,000 naira into such schemes, that would not have the same level of sophistication or the same level of information that will let them know that these are illegal schemes, the law should be able to give them some leeway. Again, in Nigeria, we have seen that argument made, but fortunately, apart from Ocheji and CBN, the later decisions appear to at least allow some level of concession to people who have invested in such schemes to allow them to do their recoveries. Of course, from an insolvency perspective, when it comes to Ponzi schemes, the route would be liquidation. So I was having an argument with someone as to which insolvency tool would be the best. And I said, look, first of all, the first problem when it comes to Ponzi scheme, unlike other types of fraud or insolvency matters, is that there is a large pool of creditors. There is an incredibly large pool of creditors. In fact, we are dealing with one where there are over 5,000. And so the moment the ship sinks, there is that immense rush for collection of assets. And that makes it a disorganized process. So you can't talk about administration at that point. What you would talk about would be a liquidation. And that is why when we work on some of these matters, I advocate that the liquidators, whether provisional or otherwise, that are appointed to oversee some of these things, should have the best interest of all the creditors at heart, as opposed to one or two creditors. Otherwise, it would create a scenario where all the creditors will still be fighting over these assets. So for me, if you are to achieve some level of sanity and recovery when you are doing the work, you have to go through the route of liquidation. Of course, even before that, the first step would be for you to do asset tracing. And at the beginning, I have said that for us as practitioners, when you are doing your asset tracing, do not limit yourself to Nigeria, right? Always know that the person who had promoted that Ponzi scheme knew what he was doing at the beginning, and so would have created an elaborate scheme to either move the asset to a third party or to move the asset offshore. So you have to be really careful, and in fact, perhaps think about getting a forensic auditor or a forensic investigator to assist in doing the investigation even before the insolvency proceedings start. Now, a very viable tool that one can also use would be the civil route, or the criminal route, and that would be reporting the matter to the law enforcement agencies and to the regulators. The big regulator in the industry would be the Securities and Exchange Commission. Again, when I interact with some of these investors, right, it then turns out that they blame, for instance, SEC for being the cause of the problem as to why the Ponzi scheme failed. That it was when SEC intervened, right, and publicized the fact that this scheme is not registered, that is when that scheme actually failed. So it then puts you in a dilemma as to whether the regulators should even intervene in such scenario or not, when the persons who they are going to intervene on behalf of would at the end of the day say that they are the cause of the reason why the scheme in itself failed. So, but to my mind, I think that given the fact that it is illegal from beginning, the intervention of some of the regulators would be needed as often as possible. What I would encourage on the part of the regulators, especially SEC, is to intervene early as opposed to at the late stage when things have gone bad. Because if there is an early intervention, then the Ponzi scheme wouldn't even affect as much number of persons as it would ordinarily affect. So at the end of the day, if you as a practitioner would want to take steps, of course, the right channel would be to go to the regulators and speak to them and then get them to act in respect of the matter. SEC has been very active in the industry and they've been assisting in some of these Ponzi schemes, right? Another beautiful intervention that has been done is with the new laws that has been enacted, the Proceeds of Crime Recovery and Management Act, which then brought up the non-conviction-based procedure. And that would be of interest where the promoters would have absconded, right? And you will not be able to get the promoter, right, of such a Ponzi scheme. But at least you are able to get some assets. Then using that procedure, you are able to get the asset returned back or at least get some form of restitution for the victims of such Ponzi schemes. So, even if the promoter is dead, for instance, and that is what typically happens, most of them run to some of these offshore countries like Dominican Republic and all that, you will still be able to at least carry on with your restitution work for the victims of such Ponzi schemes. Thank you very much.
Thank you very much, Mr. Umeke. I think now we understand what Ponzi scheme is, how it starts, how a lot of times it doesn't really start as Ponzi schemes. It starts as overambition with some of these some of these businesses, and then leads to these schemes that becomes fraud. We understand how to identify them now as investors, based on registrations, based on regulations, based on the unrealistic promise of return on investment, which is what a lot of people look out for, really. For someone to tell you that you make 50% return on investment in 1 month, it means you are also looking for trouble, because what kind of investment will you do to get that, right? It's been also able to talk to us about the tools, criminal and civil tools in the case of recovery. Also the steps in recovery, asset tracing, liquidation. He also mentioned for insolvency practitioners, in the case of asset tracing, we should focus more on these jurisdictions where they actually hide these assets so that we don't waste a lot of time going through processes in Nigeria or countries where you know that nothing is safe, right? Thank you so much. That was very insightful. A round of applause for him once again. I don't know if we have our questions together already for him. We have about 10 minutes for that. If we do, please let's quickly pass them forward so that we can quickly handle them. While that is going on, while we are getting the questions together, are there cases, Mr. Umeke, where in the case of recovery, you can actually use both civil and criminal insolvency rules to get this, to recover lost assets or stolen assets in the case of Ponzi schemes or frauds?
Yes, yes. So you can, right? You can use that simultaneously, right? You can, and indeed that's what happens in most cases. You can, even as a private practitioner, initiate the civil route. What would typically happen is even once, because like I said, Ponzi schemes have a large base, right? A large victim base. So once the bubble bursts, the regulators, the law enforcement agencies, even without being invited, they actually come in, right? So these things can be done simultaneously, both the civil and the criminal route.
Okay, thank you. So when you mentioned that some of these assets are hidden away in this other jurisdiction that you refused to mention, are there regulations that compel them, in a case of insolvency, to release these things when these cases are brought forward? Are there regulations that compel these jurisdictions to release assets in a case of insolvency cases, in a case of criminal cases?
So there are, right? It's not as if I didn't want to mention. I just don't want to be sued for defamation. But I now advise myself, a country can't sue me for defamation. So, you look at the BVI, for instance, you look at Dominican Republic, some of the typical tax haven, right? St. Kitts and all that. So, again, it depends on the jurisdiction. I know in Cayman Islands, right, they are now very big on some of these disclosure and cooperation, right? In the BVIs too, right? So there are, but it depends on which. So what I know they do, that's these promoters, is that they do their research. Like I said, from the beginning, they know what they are going to do. So they do their research, they look for a safe haven where that doesn't have that strong regulation in place. But I think over time, most of them are already, just like what happened in tax, most of them are now tightening up their regulation. And so that is actually what some of us as insolvency practitioners then exploit to ensure that there is proper asset recovery work in those.
Okay, Mr. Richard wants to say something. Please, can we have the questions now?
Yeah. Sorry.
Okay, please, before that.
What I was just going to say was as well, so with things like a Ponzi scheme and where money has trickled out, as Mr. Umeke said, usually it will go to the offshore jurisdictions like British Virgin Islands, like Malta, like Cayman Islands. And two things you need to do in my experience. One is follow the money. You want to see where the money's actually gone. And one of the most powerful tools I will often use for that is if the transactions have been in US dollars, then every single transaction in the world that takes place, whether it's between Nigeria and Kenya or between Nigeria and Cayman, wherever, if it's in dollars, it gets registered on the chip system in New York. And so what one can do is if you have proceedings open here in Nigeria, you can make an application in the US using section 1782 of the US Civil Code, and it will give against the chip system, and it will actually show you where the money went. So as long as you have the starting account here in Nigeria, you can see where the money went to, which accounts it passed through, and where it ended up. So that's the first thing with the offshore. The second thing is often you'll know somehow it went to the BVI, to a company or whatever, but you won't know anything about that company. You'll then have to make applications against the corporate nominees, against the auditors, against any third parties that have information in the BVI to try and compel the documents so that you can see what the position's been.
Yeah, just to add to that, so one of the other tools that we use, because like I said, there is usually a rush for collection of assets, right? So, and that's where we actually come to England, is to do a worldwide freezing order, right? So what that then allows you to then do is with that, so the English courts are very well respected and very responsive to granting that, and then we then use that to then deploy the asset tracing. So with the worldwide freezing order, at least you are sure that you're able to have some sort of vesting rights when it comes to these assets. And then you then start deploying various innovative tools to then trace those assets, right? So, but like I said, my experience is that for the large Ponzi schemes that we've acted on, you may find some of the assets in Nigeria, but not in a large number. You would typically then have to trace it, to do the asset tracing to some of the offshore jurisdictions. But the first thing you would like to do is to go to England, right? I'm not saying that Nigeria is not a good place to get that order, but I mean, because you want to act in a foreign jurisdiction and you would want something that would be very efficacious, then you go to England, get a worldwide freezing order, and then start going to these jurisdictions. Yeah.
Thank you very much. There's a question here.
It's not working. So I am curious on something. My name is Obinna Akbuchuku. I'm a partner in Allen and Malibon Law Firm in Onitsha. So since in Ponzi schemes, there are sometimes hundreds or thousands of creditors, I'm curious as to how a provisional liquidator is appointed. Because there may be hundreds of creditors that are at the echelon with equal rights. Maybe their indebtedness, the company's indebtedness to them are equal.
The matter is that when you are investing in a Ponzi scheme, you would know that it's a risky business. Right? You should know. That's the truth. The people that I'm very sympathetic to are the ones that were not Ponzi schemes but pivoted into a Ponzi scheme, right? But if there are no assets, there is nothing you can do. In fact, I tell potential clients, not just for Ponzi schemes, but for general fraud matters, right? If I am not able to trace assets, forget it. Let's just leave it. It's not worth it. Because even if I'm talking as a practitioner, for the greater good, it will be best to bring the promoters, whether of the Ponzi scheme or outright fraud, right, to bring them and jail them. But as a private practitioner who is interested in getting restitution for my client, I'm more interested in the assets. And so if there are no assets, there's nothing you can do about it, right? Everybody will have to count their losses, which I think is why the regulators should do more of awareness. I know that, for instance, the SEC, that's Securities and Exchange Commission, they are doing that. But that should be done more often and at the early stage so that people don't even get to invest in some of these things. Yes.
I agree with everything that's said there, and obviously if there are no assets, there are no assets. However, there is one slightly wider thing that can be looked at. So if I give you an example at the moment of a major Ponzi scheme where there are 5 different sets of proceedings around the world, the case of OneCoin, which you may or may not be aware of, I myself have had some involvement in that. One of the key things there is that the money's disappeared at the moment. There's no immediate assets. However, what's being looked at is the liability of third parties. So the law firms that were involved, who are insured, the banks that were involved, who are insured, the auditors who were involved, who are insured. Question is, did they facilitate the perpetration of that fraud? So what you can also look at with these sort of things is not only does the potential defendant have assets, does the potential defendant have money that can be recovered, but also are there any third parties who may bear accessory liability and may therefore have pockets that you can recover from?
If I can just add to that, right? That's a very fantastic approach, right? But you see, the problem is that the test is, as opposed to the person who is the promoter, the test is much more heightened. So I give you an example. It's not a Ponzi scheme, but it was a fraud case. The JP Morgan Nigerian case, right, that we lost in England, right? In that case, Nigeria tried to hold JP Morgan responsible for some of the third-party fraudulent activities that went on. And at the end of the day, the English court still found them not liable. So it is a fantastic approach that one can explore. Again, to the judges in the room, the problem is the test that you then set, or the bar. If you flip it, right, the question is, do you want, as a lawyer, perhaps you have a business that you were advising on and you never knew it was a Ponzi scheme, and then tomorrow something then happens, and then do you want to now start getting sued as a lawyer for given the fact that you represented a Ponzi scheme previously, that you weren't even aware that it was a Ponzi scheme? So those are the points. But Richard, that's a sensible approach that can be used too.
All right, thank you so much. I know it's a very interesting topic, but we have to end this here. However, Mr. President has something to chip in for just a minute before we move on to the next topic?
Thank you very much, Madam Chairman. I just want us to also kind of expand the horizon, because I think we should also know that in this kind of cases, these perpetrators also hide money in digital assets. So we must also look at the technology for tracing digital assets, because we're talking about cryptocurrencies, NFTs, we're talking about Bitcoins. So we must also know that there is technology available for searching or tracing assets that have been hidden in digital form. Thank you.
Thank you very much, sir. So much so that we are in the digital age. Everything is going that way right now. So thank you so much, Mr. Amala. It was very insightful. Thank you for your time. I think we can release you now, right? All right. So going into the third topic, our panelist is going to be presenting virtually. She's going to be speaking on the...
It's become a highly regarded and respected international forum for discussion of cutting-edge issues related to insolvency law, addressing both domestic and cross-border insolvency issues. The theme of my presentation is the first text of UNCITRAL in the area of insolvency law, the 1997 model law on cross-border insolvency, its framework, opportunities, and drawbacks. Since the adoption of that text, UNCITRAL has authored numerous other texts in the area of insolvency law, and most recently, it's the 2021 Part 5 of its legislative guide on insolvency law, on simplified insolvency regime for micro and small enterprises, 2019 model law on enterprise group insolvency, and 2018 model law on recognition and enforcement of insolvency-related judgment. First, about what we mean by cross-border insolvency. Cross-border insolvency may cover different situations. Could you please go to the previous? Yes, thank you. For example, where an insolvency debtor may have a registered office in Nigeria, but it may have branches, representative offices, or other presence in other states, or its assets or creditors may be located abroad. In all those situations, there is a high probability that insolvency proceedings concerning the debtor with its registered office in Nigeria will be commenced not only in Nigeria, but in those other states where the debtor has presence, assets, or creditors. There is also a high probability that creditors in different locations will try to commence individual enforcement actions and execution against the debtor assets. This would result most likely in the race for the debtor assets and ring-fencing local assets for protection of local creditors. This also most likely lead to piecemeal sale of the debtor assets, which doesn't generate usually much profits for distribution among creditors, in comparison with the sale of the same assets in combination or together as a going concern. The solution is coordination and cooperation in cross-border insolvencies. The next slide, please. But the usual challenges arise in administering cross-border insolvency cases in coordinated and cooperative manner. Many, but not all of them, are summarized on this slide. Some challenges arise from the inadequate legal framework. For example, recognition and enforcement of foreign acts in many countries still involve cumbersome procedures and requirements, such as exequatur and legalization, or other diplomatic and consular actions under bilateral or multilateral treaties. Those requirements could cause much delay, which is unaffordable in situations where taking a speedy action is vital, for example, to prevent dissipation of assets, especially in the digital context. In addition, courts in many countries are not explicitly authorized to communicate, cooperate, and coordinate with their foreign counterparts. In the absence of such explicit authorization, they rarely do that, since they think it's outside their powers. They may also hold the view that court-to-court communication, coordination, and cooperation may impede their independence. Those challenges are law or legal tradition rooted and may be resolved through legal reform if there is political will to resolve those. But there are also challenges of a more practical nature that cannot be resolved through legal reform, but rather through infrastructural and institutional measures. For example, case management and translation issues may be resolved through employment of technological solutions such as artificial intelligence. A lack of the adequate framework to handle cross-border insolvencies may produce broader implications, for example, on the flow of investment, access to credit, and employment. It's no surprise, therefore, that multilateral development banks and International Monetary Fund promote the enactment of the model law in the context of their programs aimed at financial stability, access to credit, and sustainable development. Next slide, please. UNCITRAL cross-border insolvency framework primarily deals with law-rooted challenges, but some texts are directly relevant to judicial capacity building. In addition, the UNCITRAL Secretariat, in its technical assistance, capacity building, promotional and dissemination activities, touches upon practical issues arising in cross-border insolvencies. The UNCITRAL cross-border insolvency framework consists of many texts, as you can see from the current slide. To save the time, I am not going to go through all of them because the cornerstone is in any event the model law on cross-border insolvency adopted in 1997. It was adopted as a model law, not as a treaty, and therefore there is flexibility for enacting states to vary the terms of the text. And in fact, many enacting states deviate from the model law, which I would briefly touch upon later on. Next slide, please. We can say that the model law is one of those UNCITRAL texts that stood the test of time. This is evidenced by the different years of its enactment by states. You can see that most recent additions are from 2020 and 2022. You can also see that states from different regions and also from different legal traditions enacted the model law. The next slide, please. The model law is built around several concepts displayed on the slide. The first one is the concept of the foreign proceeding, which has generated much case law and led to the amendment of the Guide to Enactment, which is now called Guide to Enactment and Interpretation. The Guide of Enactment and Interpretation of the model law, which is also very often cited by courts, explains which proceedings would fall within the scope of the model law and which do not. Again, because we do not have much time, I will not go through those, but would invite the audience to consult the guide for these explanations. The next concept for the model law, the key one, is the foreign main proceeding. And this concept is very much linked to the notion of center of main interest, or abbreviated COME. The foreign main proceeding enjoys more assistance and protection under the model law than other proceedings. In particular, automatic stay of proceeding and suspension of debtor asset transfers flow from recognition of only the foreign main proceeding. Relief granted to other proceedings must not interfere with the relief granted to the main proceeding. And that relief granted to other proceedings also must be limited to the assets or information administered in that other proceeding. The model law therefore envisages subordination of other proceedings to the main proceeding. The concept of COME is not defined in the model law, but the presumption is that the registered office is the COME in case of a legal entity, habitual residence in case of individual, but this could be rebutted. The next key concept is foreign non-main proceeding. This is a foreign proceeding other than foreign main proceeding to take place in a state where the debtor has an establishment. And the model law defines the term establishment as the place where the debtor carries out a non-transitory economic activity with human means and goods or services. Finally, the model law has also the concept of the foreign representative, which includes persons appointed on an interim basis, and that person must be authorized in the foreign proceeding to administer the reorganization or the liquidation, or act as a representative of the foreign proceeding. The next slide, please. The slide sets the main building blocks of the model law. Those are access, recognition, relief, cooperation, and coordination by courts and insolvency representatives, and also coordination of concurrent proceedings. As regards access, a foreign representative has the right of direct access to local courts and can apply to commence local insolvency-related proceedings. No recognition is required for those steps. In addition, the model law dispenses with the requirements of any diplomatic actions, as I have already said. Additional rights of access are given to the foreign representative after recognition of the proceeding. For example, to participate and intervene in any local proceedings, or to have a standing to initiate avoidance actions domestically. Foreign creditors have the same rights as local creditors, with some exceptions. For recognition, model law requires certified copy of relevant documents, but some other evidence may be admitted by courts. Translation to the official language is optional, but there is a requirement to disclose to the receiving court information about all other foreign proceedings that are known to the foreign representative. The model law recognition framework is very, very expeditious, because model law not only requires complete recognition at the earliest possible time, but also suggests measures to achieve that. For example, presumptions of authenticity and accuracy of documents, of comment, etc. The model law also facilitates certainty, since it provides clear criteria when the foreign proceeding must be recognized, and when it must be recognized as a foreign main proceeding, and when the foreign proceeding must be recognized as non-main proceeding. There is no discretion of courts in that respect. 3 types of reliefs are available: interim relief between application for recognition and recognition if granted, automatic stay or suspension, about which I already talked. This is linked to the foreign main proceeding, and relief to be granted by the court on a case-by-case basis. It could be for main or non-main proceeding, although often referred as discretionary relief. Appropriate relief is expected to be granted when it's necessary for protection of the assets of the debtor or the interest of the creditors. I already touched upon cooperation and coordination and importance of direct communication among courts, which is enabled and facilitates. This provision was hotly debated when the model law was prepared. Another safeguard is in the discretion of courts to subject the relief granted to conditions it considers appropriate. There is also the envisaged power of the court to modify or terminate the recognition or the relief granted. And my next slide is the last one, substantive, where I am listing issues arising from the use of the model law. They are grouped into 3 categories: those arising upon enactment of the model law itself by states, the second one upon application for interpretation of the model law by courts, and the third one touches upon issues arising from practitioners' use and other aspects. So I would not have time to go in detail into those issues, but I would invite all interested to consult not only the guide to enactment and interpretation of the model law that touches upon many of those issues, but also very important publications of UNCITRAL, such as a practice guide on cross-border cooperation in insolvency cases, then the digest of case law on model law on cross-border insolvency, judicial perspective, and our case law online collection on model law on cross-border insolvency that has more than 150 model law related cases, and they touch upon many of those issues that I listed. And the UNCITRAL Secretariat is currently also planning to create an online insolvency training module for judges and insolvency practitioners. Thank you very much for giving me time, and sorry if I exceeded the time requested.
Thank you very much, Ms. Samira. Thank you for taking us through the ancestral model law, which basically aims to provide a structured and harmonized approach to dealing with insolvency cases that involves entities operating in multiple jurisdictions. That's the summary of the law. The model encourages cooperations and coordination amongst courts, insolvency practitioners, and other relevant parties involved in cross-border insolvency cases. We've also been able to look at the challenges with the law, with the model law, the legislation based or influenced by model law across different jurisdictions, the safeguards the model law has provided in insolvency cases, and the issues arising from using the model law. A round of applause for her one more time. Thank you very much. All right, so we have one more topic, and this is the one I'm actually looking forward to. It's insolvency and restructuring in a digital age, talking about the challenges and the prospects. Mr. Rogers Terry, I can't pronounce the other name, will be taking us through this topic. It's also going to be virtual. In the meantime, I hope we have our questions ready for Ms. Amira, because after this, we'll take questions for the other 3 topics that we're taking. All right, thank you. The floor is yours.
Thank you very much, ladies and gentlemen, distinguished colleagues. Good morning and good afternoon from my end. It is indeed a great pleasure to join you today virtually from Dubai, this BRIPAN conference of 2023. I extend my sincere appreciation to the executive of BRIPAN for this wonderful opportunity to share my experience and insights at this conference. Our topic of discussion today is insolvency and business restructuring in a digital age. And this is both timely and very relevant. I have the opportunity of working in a place where I see this firsthand, and I'll be happy to share my experience so far. Over the next 20 minutes or 15, as my colleague took, I'll be able to delve into the intricacies of insolvency and business restructuring in an era characterized by rapid technological advancement, digital disruptions, and an evolving regulatory environment. I hope that by the end of this, we are able to at least know and understand the role of technology in this space, and the fact that technology is here with us, and that we need to adapt as soon as possible. So I request I could share my screen. Just give me a moment to share my screen. Okay. I hope my screen can be seen, and so I'll just dive into it. The agenda for today is really to discuss from the introduction, and then I'll unveil the opportunities and, of course, the challenges that are faced by the adoption of this technology. We'll go to the way forward, and then I'll be able to conclude. I'll start with a quote that really caught my eye, and this is from a gentleman called John J. Ray. John J. Ray has been involved in some of the biggest bankruptcies. If you know the bankruptcy of Enron, the bankruptcy of Residential Capital, and all these other bankruptcies. And recently, he was appointed as to take over FTX. As you know, that was a crypto exchange that collapsed, I think, just last year. And he makes a very outstanding statement. When you see the very end, he says that I have over 40 years of legal and restructuring experience. I have been involved in some of the largest bankruptcies, and never in my career have I seen a complete failure of corporate controls and absence of trustworthy systems. And then he says that technology is ahead of all of us, the practitioners, the regulators, and the judiciary. And this is a very telling statement, because many times the practitioners, the regulators, and the judiciary, we are just playing catch up. And so the earlier we realize that we must adopt these technologies, the better. I'll be able to share what the statistics look like from an INSOL study that was done in 2019. So it says that only 35% of those people who responded, because these were insolvency practitioners from all over the world. It says that only 35% of the responders confirmed that they had used artificial intelligence for technology-assisted review. So we still have a big gap in that, to that extent. Only 10% at that time had come across smart contracts and blockchain in their practice. 64% said that they had never come across blockchain or smart contracts in their practice. 43% said they had not, that they were actively deploying cloud computing, and then 80% agreed that cloud storage and cloud usage and related issues were increasingly becoming a feature of insolvencies. You will see that only 7% had dealt with cryptocurrencies and related issues, and then 32% had responded that they had absolutely no awareness of this crypto business. I'll be able to discuss where technology meets insolvency, and I'll just still talk about the numbers so to bring the picture closer. If so, you will see that e-commerce is the first section where you see that technology is meeting insolvency, and the value now is at $6 trillion, which is more than 20% of the global retail market, and it's really growing. So with this e-commerce growth, and I think Nigeria is obviously the largest e-commerce market in Africa. With this growth, these companies need people who understand the intricacies of technology, because their backbone is technology, their business model is technology. And so for us, the earlier we learn that, you know, technology is with us, and in the sense of e-commerce, it will be a very good thing. So I just wanted to mention, for example, a real practical example that has already happened. If you've heard of the Dubai International Financial Center, they set up, 2021, they set up the world's first digital economy court. And really this is to, so the areas of where they capture is robotics, they capture artificial intelligence, they unmanned aerial vehicles, and so much more. So what Dubai is doing is positioning, because now you have a lot of capital flowing into e-commerce, and so what they are doing is to position themselves and create a really sophisticated but also all-embracing court. Because you could be in Nigeria, you could be anywhere in the world, and you choose the DIFC courts as your, you know, as where you'll have your dispute resolved. And so that's, you know, the first section. The second will be on e-governance and process automation. Where I am today, all government processes are all digital. There's absolutely no paper involved in Dubai and most of the UAE today. And so we see most of the governments increasingly going digital if you're applying for company setup and so much more. So with these automated processes happening and courts automating, obviously now as insolvency practitioners will find ourselves in that space. You'll see it's not unlikely that you will call a bank or call a telecom company, and the responding voice on the other end is a chatbot or something that has been taught natural language. So we deal with that in self-executing contracts and e-signatures every single day. We click on agreeing to terms and conditions every single day. So this is happening in our daily lives. So we need to be abreast as insolvency practitioners. The third section will be on data and cybersecurity. As you know, data is the new oil of the digital economy, and cloud computing has grown immensely in the last 10 to 15 years. We as insolvency practitioners handle large and complex data sets, and sometimes we even apply for urgent disclosures from the judiciary. So this obviously applies to us as insolvency practitioners. The third part is on digital assets. You you realize that the global market and the market value of digital assets today stands at $3 trillion. And these involve digital currencies, NFTs, which are non-fungible tokens. And these have become mainstream in many parts of the world. So the previous speaker talked about it. Mr. Mala talked about Ponzi schemes and hiding in digital assets. And this is here with us. So that's another area where you find technology meeting insolvency. The last would be on social media. We have 4.8 billion social media users, which represents 59.9% of the global population. We recently saw a Canadian case of Southwest Terminal, where a thumbs up emoji was accepted as, it was proved to be a valid means of acceptance of a contract. So social media is here with us, and there's a nexus between there and technology, insolvency and technology. And so I'll discuss the first opportunity, which is on technology-assisted review. Technology-assisted review is something that is largely done by artificial intelligence, and machines are taught over a long period of time. They mimic human senses. They are able to extract the evidence. They are able to identify themes and the key information that you need. And so the first advantage is that this is done so quickly with technology-assisted review. In the UK, we've seen it was in 2017, where they adopted, the Serious Fraud Office adopted the first AI, artificial intelligence technology-assisted review. I think it was called iManage RAVN. And the capability of the RAVN is that you have this artificial intelligence being able to at least extract the right information within at least 500,000 documents within a day. That is not humanly possible. And so these are things that we need to take on as soon as possible. The second advantage is that it helps you to accurately, quickly, and very fast do this thing. The last would be it tracks performance, and it creates evidence-based key performance measures, which might assist, especially for companies that are not yet in liquidation or insolvency, to have advanced warning signs. I was told by Mr. Okori that I have to give actual examples of where this has happened, and I'm happy to share that, of course, iManage, if you could just record that and take your time and read through what they're able to do. iManage RAVN was used in the Rolls-Royce investigation, and it did 30 million documents, and they were able to sift through all these and get what they wanted. The second I picked out was HiQ, which is a case builder. It helps you e-discovery, and it can review 11 million documents within at least a span of a month. The other I looked at was Lex Machina, Westlaw Edge, and Sarada. When you get some time, you can look at how these platforms are able to help and work very fast. The second is on professional opportunities. You could choose to become a digital forensic analyst. And these are things that are already happening. There are people who are reskilling in this area. You're not just an insolvency practitioner, but you're taking on all these. You're just reskilling because this is very important. You could become an insolvency data analyst. You could become an insolvency technology solutions analyst and learn to build these systems. Cryptocurrencies, we talked about that. Cybercrime, white hat hackers. These are the good guys of hacking, especially where they hide crypto assets. Crisis management specialists, and so on and so forth. I'll try to rush through it because I have only 5 minutes. And the third opportunity is on data-driven insolvency systems, which is very key because a data-driven insolvency system for any country is something that you want. What does it take? It takes a data-driven insolvency system, really, has to take into account time when the data defaults and until a solution is found, the costs involved and the recovery rate. And the beauty of a data-driven insolvency system is that it tries to capture the context and the history and the country-specific circumstances of each country. So you're happier to have, a system and legislations that are based on data that is acquired from the system that was built within that country. The country I found to be, very leading the way in data-driven, in trying to capture data in how they, try to do their legislations is Spain. You can see all this data is captured, and then it helps in how they work on the insolvency system. They capture judicial statistics, they capture the NPLs in the market, and so much more. And so they're able to build a data-driven insolvency system because this artificial intelligence is able to pick all this information from several places. I'll quickly dive into the challenges because the time is not there. The first challenge we already discussed is on hiding of digital assets. As you know, these digital assets are decentralized, they are anonymous, and they're very volatile in nature. So the first thing is how do we need to find ways around it. I know that someone is going to discuss tracing digital assets, so I will not go into that. But of course, it has to be a concerted effort between insolvency practitioners, regulators, law enforcement, and the judiciary across all jurisdictions. Social media sensationalism is a big problem with technology. And as you know, when you take over a company and social media is bashing, and it just quickly makes the collapse worse. It escalates it. And one of the areas we could interest ourselves in is in the concept of the right to be forgotten. If a company has been restructured and it's back on its feet and is running properly, you as an IP, you have a chance to apply to at least Google, because there are cases that have been decided, and they can erase that history of the search engines, such that the company, as we say, bankruptcy, when you go through the process, you get a fresh start. So that is very key. Data management and data security, because as insolvency practitioners, we hold sensitive financial and personal information, and these are susceptible to deletions, distortions, and of course, multi-jurisdictional issues, because you have a company that is, for example, in Nigeria, but the servers where the information is in Silicon Valley. So the multi-jurisdictional issues. The other challenge is on adoption costs, which is one of the biggest challenges. Of course, knowing that different jurisdictions, different clientele, and so on and so forth. It's obviously expensive, and it's constantly evolving. You have to keep up. Just like you see iPhones every other day, 15, 16, like that. So you have to keep up, and the cost is not small. But we could try to pool resources in associations. Association like BRIPAN can you pool resources and have AI for something that is designed for you, and then it's such that you catch up. You don't do it individually as firms or as individual insolvency practitioners, but you do it as an association. The last would be autonomous decision making, which is a big problem with artificial intelligence. How do you decide who has made the decision? If the artificial intelligence is the one which has looked at the information and given you a decision, who takes liability? So that's a big challenge. Also, on fair credit reporting, most of these systems are designed by people in another part of the world, and you find that their biases and things like that are already embedded in the artificial intelligence. We have to adapt, we have to reskill, we have to invest, and we have to embrace. That's the way forward. And then I just wanted to conclude by saying that an insolvent company is a melting ice cube, and time is of the essence. What technology gives us then is the opportunity to be able to improve efficiencies and be able to do our work much better. Thank you very much.
Well, Thank you, Mr. Terry. Thank you for your insight into that topic. It's been able to take us through the link between technology and insolvency, looking at e-commerce, e-governance, and process automation, data, cybersecurity, and data protection, digital assets, and social media. Also, we looked at the opportunities, which are technology-assisted review, professional opportunities, and data-driven insolvency systems. He also mentioned the challenges faced with insolvency in a digital age, basically hiding of assets, social media sensitization, and data management and data security. Also, adoption costs and limited training, and ethical challenges around AI. The way forward is proposed where adaptation, we are to adopt technology, reskill. The regulators and the judiciary should endeavor to reskill. A lot of investment in data-driven insolvency system, and for regulators and judiciary system to be able to embrace data-driven insolvency system. All right, thank you so much, Mr. Terry, once again for the topic. Okay, that is the last one. I don't know if we have our questions written down now. If we have them, you can please give them to the usher so that we can read them out. We have a very few minutes for that. If you want to speak, they can get the microphones to you now. We have about 10 minutes to just take a few questions so that we can move on to the next session. While that is going on, Mr. Terry, one of the challenges you mentioned is data management and security in this era of increasing data reliance. How do insolvency practitioners and restructuring professionals handle sensitive financial and personal data while still ensuring that they comply with data privacy regulations? I don't know if you can hear me.
Yes, I can hear you very well.
Yes.
Of course, this is a challenge not just even for insolvency practitioners. We see that even places like Facebook and you saw the recent hacks. There's a lot. Even the companies that do the most are hacked. But we can do the minimum, at least try to have measures in place. So I think it's possible. There are many tools around this. It's a challenge, and it's something that keeps growing. There are many solutions which involve, of course, largely trying to protect the data. As an insolvency practitioner or as a firm, you can adopt security measures that are at least the bare minimum, antivirus and things like that. Most firms, sometimes we work without, you'll be surprised that people work without, not even an antivirus on some of these computers, or try to click on some of these emails which are sent by people who are phishing and trying to siphon information. And the moment you click on that link, you're finished. So it's really to train people to try to invest in some of these security measures, at least try to do the bare minimum.
Thank you so much. I guess it's still work in progress. We still keep trying to work at it to make it better. Yeah. Mr. Richard and Ms. Samira, talking about the ancestral law, there are 59 states and in 61 jurisdictions where the model-based or influenced model law has been enacted. Is there a plan to increase this? What is the model doing around expanding their reach? Obviously, we've not been able to enforce that in Nigeria till date. So what are we doing to be able to achieve that?
As regards the UNCITRAL Secretariat and UNCITRAL, of course, the General Assembly and UNCITRAL themselves, they're encouraging states to use this model law as a template for national enactment of cross-border legislation. But we cannot do more than that. And there is capacity building, there is promotional activity, there is dissemination activity. However, it's up to states to use that text. And very much it depends on political will of a particular government to do so. But there are many partners around the world, like Insol International, International Insolvency Institute, of course, World Bank and the International Monetary Fund, that promote this text as the model. And as I mentioned in my presentation, this is very much relevant also to programs of IMF and the World Bank related to financial stability and sustainable development. And the text is, of course, also very much relevant in a regional integration context and also international integration context. It's no surprise, therefore, that, for example, in the European Union, insolvency matters regulated at the EU level, and perhaps with Africa trade agreement and protocols, etc., this will become also high on the agenda of African states. But you saw on my page, one of the slides, that in fact among most recent additions among connecting states are those also coming from Africa, Angola, Rwanda. So, and OHADA itself, with all its member states, also implemented the model law through its Uniform Act, which is directly binding and applicable in its member states. Thank you.
Thank you very much. I don't know if Mr. Richard has anything to say to that.
Yeah, the only thing I would add is I think it's important to bear in mind that the fact that as yet Nigeria has not yet enacted the model law does not prevent insolvency practitioners from Nigeria accessing other states that potentially have. So just because Nigeria has not yet got the system in place doesn't mean that they can't access other courts in other jurisdictions that have, because they can.
Thank you. Compared to traditional practice, how has the digital age transformed the landscape of insolvency and restructuring? Looking at it from the ancestral law, looking at it from the English courts, even Mr. Terry's conversation. So how has this new age of technology and digitalization affected the transformation and of the landscape of insolvency and restructuring generally?
Okay, so from my experience, because I've been doing this a very long time, in the old days, when I used to be involved in an insolvency where there'd been fraudulent activity, we would go out on the first day and we would raid the company premises and we would seize the books and records, and we would effectively go with the police, get an order, seize everything and question everybody. That's all largely gone now because things have changed. So one of the key things now with these sorts of investigations is to secure the electronic records. So it might well be that at the first stage one needs to get hold of the computers, but one also needs to ensure that the records that are, for instance, held in the cloud, cloud-based technology, is also secured. So what one can do now is things like where you don't get cooperation from the company, its management, etc., one can, and one regularly does, go off and get orders against people like Google and WhatsApp to seize records and effectively interrogate those records in a way that one used to do with kind of the old paper-based documentation.
All right. We have someone here that wants to speak.
Thank you very much. I have a couple of questions for both Richard and the ancestral. Of course, in Nigeria, we still are very used to the traditional receivership where you take over assets. But of course, we know the campaign is more or less tending towards rescue. And if you look at the UK provision on SIGA 2020, they are also more or less preaching rescue. We don't, looking to the future, I mean, our theme, how can that work in Nigeria, particularly when you still recognize financial debts and liabilities likely being classed as pre-moratorium debt, you know, without payment holiday. So which means the creditors can still, you know, disrupt whatever rescue process you are putting in place. How do you think that can work in the Nigerian system? Richard, please.
Okay. So it's difficult for me to comment too much on the Nigerian system because, as I said at the outset, I'm not sufficiently familiar with your system. What I can talk about in the context of rescue and turnaround in the UK is that now we do genuinely have a culture of we'll grant a period within which no actions can be brought against the company, whether it's by way of administration, whether it's by way of now a restructuring plan. We'll put that to the creditors. We'll go to the creditors and we will go and seek to get buy-in from the key creditors. So it's a question of taking a more proactive approach and actually going to the creditors with a plan and with a rescue proposal before, if you like, things start to reach the point of no return. So that has now worked and is continuing to work successfully in the UK. What you're having is less and less formal insolvencies, actually, and more pre-insolvency restructurings. So, yeah, I genuinely believe that actually following the UK model, provided the necessary legislations there within Nigeria, and as I say, I can't comment on that at this stage, but there is scope for that to be undertaken.
All right. He was able to comment on it from the UK, from the English court basis. He's not able to really speak to the Nigerian law because he's not very familiar with our systems yet, right? However, what they have over there can also be implemented here, right, based on the relationships available. That's a summary of everything he said. All right.
If I could chip in from your central perspective, if I'm allowed. In fact, the culture of rescue business has already been underlying legislative guide on insolvency law since 2004. And in our part 5 on simplified insolvency regime for micro and small enterprises, this theme is also very important. And that's why in both scenarios, in standard insolvency regime and in simplified insolvency regimes, debtors are encouraged to apply for insolvency proceedings very early, at early stage of financial distress, in order to get necessary support and assistance for the systems for rescue, rather than just liquidation. And on digitalization, we see more and more in model law cross-border insolvency cases that courts, especially during COVID time, but also now, they more and more for using video conferences and witness questioning occurs, and also servicing outside jurisdictions using Twitter, using emails, etc., non-traditional means. And as I mentioned in my presentation, there is much potential for technology to be used also to assist courts with case management, especially for cross-border insolvency cases, which require urgent attention, but courts would not necessarily see that urgency if they face backlogs and many cases that they have to attend to. Thank you for that.
All right, thank you, Samira. Because of time, we have to bring this session to a close. Please, let's give our panelists a big round of applause. They've been able to give us good insight into this topic. Thank you so much for your time. Thank you for listening to us.
Ladies and gentlemen, please put your hands together one more time for our panel. At this point in time, may we invite Mr. President, the CPC, to come and for a photo session.
Can I please invite Dr. Adebola Olubanjo to come and present our small token of appreciation to our speakers, or the remaining speakers.
Please, may we have smiles on those faces, those beautiful faces. We want people to know that you enjoyed the conference by the time they look at the pictures in future. Thank you. All right, ladies and gentlemen. Ladies and gentlemen, we are on a roll, and we don't want to slow things down at all because we have a full day's activity. We're going to be having the young practitioners debate as well before we also move into the gala night. So we really need to maximize the day. And as such, we will not be going into our lunch right about now. We'll move immediately into the very next session. Right? We're excited about having the very next session. So yes, my CPC just told me that in fact they have not recovered from breakfast, so lunch is not in view right about now. But anyway, ladies and gentlemen, we're really excited. This session was really, I want to thank Madam Chair for this session. It was really, really amazing. And for me, every time I see women do things, it just, I don't know, it just gives me the bumps. And so I want to say thank you so much. That was a beautiful session we had there. And for the next session, we'll be looking at career and professional development. And our coordinators for this session, we have Ms. Efose Were, FCIS, FCI ARB, Managing Partner, Graveda Attorneys. Please put your hands together for Ms. Were as she steps forward. We also have the beautiful Ms. Kehinde Oyebade, ACI ARB, Associate, Ayodele Akintunde and Co. Please put your hands together for Kehinde as she steps forward as well. Thank you.
Thank you, MC. Good afternoon, everyone, and thank you for indulging us. We know we had to skip lunch, but we have a very interesting session today. And just like the MC said, this session is divided into two, which is the main session and the young practitioners debates. But first, we'll be going into the session which is going to help in our career and professional development. And that session has been divided into 3 topics. First is going to be chaired by Mr. Michael Otu, who is the Group Company Secretary and General Counsel, Zenith Bank PLC. Please, Michael Otu. Thank you so much. No, you could. The walk. Thank you, sir. It shows you're very energetic. So, also, we are going to be discussing when bonds fail, financial markets, insolvency, and rescue. The speaker for that session is Mr. Haruna Jallo Waziri, but he is the Managing Director, Chief Executive Officer, Central Securities Clearing System, PLC. And he is duly represented by Mr. Charles Ojo. Please put your hands together for him. That's not loud enough, please. And also, the one who is going to be giving us an education on financial literacy for insolvency practitioners, Mr. Oluwaseyi Emmanuel Fayemi, FCA. He is the President, Sokotua Holdings Limited. Please put your hands together for him.
Before we talk about our last session, we want to recognize our immediate past president, Professor Fidelis Odita, KC, SAN, FBR. Please give a round of applause. Our final speaker for this session is Mr. Bidemi Daniel Olumide. Mr. Bidemi Daniel Olumide is the managing partner of AO2 Law, as well as Tax Aid Professional Services Limited. And he will be speaking on the topic, taxation, the law and practice of tax collection in insolvency situations. We will now hand over the session to our session chair, Mr. Michael Otu.
For the speakers, when they come in, they'll join. Due to time constraints, we really had to get this on. So please indulge us.
Good afternoon, everybody. Good afternoon, everybody. As already introduced, the topic we have this is career and professional development. Because we are mindful of the fact that we have members that will be inducted later today, as much as possible, I know that from my little view of the presentations for this afternoon, I've seen some efforts that have been made, have been put in to make it as practical as possible so that we can have some take-home points at the end of the day. We know that a career in insolvency and restructuring, for instance, is one that requires knowledge, not only in corporate law, also in business, finance, and even accounting. That is why we don't have only lawyers. We have accountants, we have other professions coming into this. Now, the association has empaneled very distinguished speakers for this afternoon that will be talking to us. So the first speaker that will be addressing us would have been Mr. Haruna Jallo Waziri. But unfortunately, for some reason, he's not available today. So he's being represented by the company secretary of the Central Securities Clearing System, my own brother, who is seated there, so he will introduce himself appropriately. And the topic will be when bonds fail, financial markets and insolvency. Bonds, we all know, are instruments and they are securities and investment securities which are utilized for various purposes, most especially by government and companies to raise revenue via borrowing. If you want to know what happened when bonds fail, I'm sure most of us invested in the Ghana bonds. And we saw a debt restructuring that happened recently. For most of us that invested in those bonds, we'll be waiting. We do not even know when we are going to be paid any coupon. So Mr. Jallo's paper is going to be presented by Mr. Charles Ojo. So we'll just listen to it because of the constraint of time that we have, I will allow him to go straight to the paper. Thank you.
Good afternoon, everyone. Seeing that your launch has been deferred so that we can continue, I will try and make this paper very short. I bring you good wishes from my CEO, Haruna Jallo Waziri. Unfortunately, he had to take an assignment . Thank you. So he couldn't, he couldn't make this conference, but he sends his best wishes. So knowing the big shoes that he wears and having to take this presentation and seeing the very eminently qualified faces that I see here, I hope that I do justice to this paper. My outline is, what you can see there. I mean, this paper covers an introduction to bonds. I move on to causes of bonds failure, impact on financial market, rescue mechanisms, regulatory measures, and risk mitigations. And then I will attempt to give you some nuggets as I conclude. Now, knowing that I'm here from the Central Securities Clearing System, and it's a market infrastructure, I am very mindful that there could be some, unintended consequences where people think I'm actually providing advice here as a market infrastructure. So I thought it was important that we put that caveat there, that this is only to cover the presentation, and if you really want advice around dealing in bonds, please by all means consult a professional advisor. Thank you. So I mean, we'll start with an introduction. And I thought this slide, is a good way to set the tone for this presentation. I mean, many people are in the room here are quite conversant with the 2023 appropriation bill, our budget that was termed the budget for financial stability and transition. And it's a very ambitious budget by every standard. Total budget at 21.8 trillion. I mean, we have, I think it was instructive to mention the fact that there's a budget deficit there, that it's circa over 11 trillion that we are looking to cover, so that at least this budget can be functional. And the question would then be, how would you expect that our government will be able to finance this budget? So essentially, I mean, you would expect that the government will go borrowing, and to that extent will issue bonds to be able to raise the desired revenue to fund the budget. And so, 11 trillion, you go ahead and you raise bonds. It's also instructive to mention that, during the inaugural speech of Mr. President, he talked very emphatically about the reforms of his government. He's looking towards electricity and power sector and saying giving, local players more energy or impetus to carry on with what it is that has been invested since 1997 in the electric and power sector. There was conversations around manufacturing and seeing how to retool or to reinflate, that industry. So how else would you be able to finance this if, you don't think to go about borrowing by raising bonds? Next slide, please. No, okay, thank you. So we thought it was also important to give you a 6-year or maybe 5.5, year snapshot of what the total value of bond issuance have been. And you see the very interesting statistics that were projected there. You see that, total value, bond issuance, the government has always been the biggest in terms of the value of issuance, at 97%. If we look at first half of 2023 numbers, and then corporate bonds, are at 3%. That 97%, is a raise to 4.7 or about 4.7 trillion, trying to be raised, with the issuance of bonds, as at the first half of 2023. Corporates so far have done a little about 12 billion, in terms of raising bonds, just to be able to finance their corporate objectives. So the benefits really is that, by this, the government can utilize, and corporates can utilize bonds, as a basis to be able to fund any shortfalls that they have. Funding infrastructural development, such as developments of roads, railway, and bridges, and I have talked about the very ambitious statements of the new administration around how to get things going. Diversification of financing sources, and also long-term financing available for the corporates and the federal government. I was told, I'm sure that Ms. Ewere had, quite a bit from me over the weekend, just trying to size the room and be able to understand, the mix of my audience. And she did say, and I also heard it, just before I got on the stage, that there's supposed to be a debate amongst newbies. And I'm assuming that those newbies could be people who are fresh, out of law school. And perhaps it will be presumptuous of me to think that everybody understands what, or the definition of a bond and can draw the parallel between it and the equities. So I thought I would touch on that, and if I am falsely presumptuous, please do forgive me. So a bond really, it's what you typically call an IOU, right? Is a debt, and so you are essentially asking that you be borrowed money to be able to finance your objectives. Sorry, I haven't moved to the next slide. This is not part of my slide, but I thought to cover it. And so, for the bonds, as I said, it's more of, an IOU, and, you're trying to finance your projects or your objectives, and so you go ahead and raise a bond. It's different from the equities. Equities is really you going ahead and buying, shares into a company, and it's more of an infinite journey with that company, as opposed to bonds, which are finite in nature, because there is a tenure for every bond that is issued. But for equities, you can hold on to the shares for as long as you want. So that, in summary, is more. That, in a summary, is the distinction between equities and bonds. We can move on to the next slide now. I've covered the federal government, and I've covered government bonds by the first slide. It's important to also see what is happening in the market. So amongst the companies that I have said have raised bonds so far, the 3%, these 3 companies. It will interest you to know that these 3 companies today are on the premium board of the stock exchange. So they are companies that are the ones really lifting the index of the Nigerian stock exchange. But they've gone on, they've seen the value in having to float bonds. Geregu Power was actually listed in January 2023, but already has a bond, a 7-year bond that has been issued. Again, this is more or less, to my mind, trying not to dilute, the holdings of the company by having to maybe increase shares of the company. So, in his wisdom, the company has gone on to say, okay, I will float a bond. And it's a 7-year bond, as I said. Dangote Industries, it's, also is on the premium board. Its principal business, which is Dangote Cement, is actually listed on the premium board. It also has done 2 series of bond, done a 7-year in its first tranche, and the tranche B a 10-year. Again, trying to finance all the laudable projects that company or the conglomerate is involved in. Access Bank too, by size, customer base of banks, said to be the biggest in Nigeria today, has also, priced a bond on the back of one that they are debuted in 2019. So you can see that there's an inclination. There is, a move towards trying to finance many of the objectives of corporates using bonds. And we're hoping that 3% that we saw in the first half of the year would ultimately begin to rise, and there will be more, interest in having to raise corporate bonds for very obvious reasons. Next slide, please. And also, we thought to touch on the causes of bond default. There are many more, but these are top of mind for us. And the first is that, poor financial position and cash flow. With all due respect to the accountants in the room, people often say that if you look closely at certain companies, you tend to find that, okay, I see I have 5 minutes left. Let me see how I can quickly rush through this. I thought I had 20 minutes. I'm not sure how far I've done in that. Can I have the slide back up, please? Okay, so poor financial position and cash flow. The second point is macroeconomics events such as recession and rising interest rates. So what we found in 2023 at around March, when COVID was at full swing, was that there was a lot of restructuring around bond obligations. There was a dash for cash, more or less, from investors wanting to hold on to money as opposed to, continue to keep them in this investment. Heavy losses suffered in corporations. So sometimes companies set out to, with all their strategic objectives, and then there are inflections that could happen across the way and impact on their corporations. And this, would also impact on their ability, if they floated bonds, to be able to meet their obligations. Blockade of money in long-term assets. It's also one of the causes of bond default. Next slide, please. The impact on the financial market is significant. There are contagion effects. And as we look at the next slide, with reference to the illustrations that we have drawn, we will see one clear example around this. So, okay, can we move back to the other slide? Thank you. And then there are also impacts in terms of credit defaults. This maybe in some sense could be seen as a positive, because it also provides for insurance so that in the unlikely event that, there's any issues with regards to the bonds, I mean, the buyer is covered. Market liquidity, reduce market depth and trading volumes. Again, when bonds fail, it has a huge impact on, on the market. We see FDIs and we see people's, aversion to coming to the market to come and invest, and that would also erode the depth of the market. Next slide, please. These are case studies. I think the Ghana one, is very evident to us. My big brother, Michael Otu, had made reference to it. Visionscape is also another example. And then the Ghana, we thought to put one example global, which is Ghana Gas from the UAE. Dana Gas, I beg your pardon, from the UAE. Now, it's interesting to point out at this junction that we've not had a sustained default of bonds in Nigeria. I say sustained in the sense that Visionscape was one that, happened, but the obligations towards the investors were redeemed by the next day. So the default was actually on the 7th, but very quickly it was resolved. So we seem to be looking good, but I guess maybe that also is because from the first slide where I showed 97% only translating to 4 trillion, and then on the government side, and the corporates 3% translating to 112 billion, you would say that not much issuance has gone on. And maybe when we have an expanse in issuance, then, we could start to test whether really we're a safe haven in terms of investing in bonds. Next slide, please. Rescue mechanisms, restructuring and refinancing, debt for equity swaps, so where they can't meet their obligation. I mean, the issuer of the bond can decide that, well, equities that I was running away from, I would have to issue to cover my positions. Extension of maturities, it's with the Dana Gas, time fails me to be able to go into that illustration. There were extension of maturity. Negotiation with bondholders, again, there's bankruptcy and legal proceedings, and I guess that's where, BRIPAN, you have some work to do to just continue to ensure that the framework around this is kosher. Government bailouts, I mean, whether it's on the, some entities are just too big to fail, and they have significant impact for us or for their climb if they fail. And so for that reason, government may need to step in. This is something that was seen in, in the US, in terms of government having to bail out companies. International financial institutions, I think we can move on that. So regulatory measures and risk mitigations, enhanced disclosure requirements. So it is important that companies that come to the market to issue bonds are closely monitored and that their transparency, levels are raised. Continuous follow-up, continuous monitoring, because, I mean, between the time when they issue and when, they eventually redeem those bonds on maturity, a lot could happen. There could be inflections along the way. Strengthen bond governance. Again, tighten default triggers, covenant protection for bondholders, contingency plans. Improve credit rating practices. I mean, it's something that we cannot overemphasize. The needs for proper, credit ratings of the bonds that are issued. Today, typically you have them in alphabetical orders, whether the triple A's or the triple B's. But behind, those rating issuance, is it something that we can hold up anywhere and say, okay, yes, indeed, proper ratings have been done? These are things that will feed into regulatory measures and risk mitigation. Market surveillance oversight. The infrastructures in the market do a pretty good job, but I think that, you need to now begin to elevate those market surveillance and oversight. Next slide, please. Okay, so I'm now on to the conclusion. But my conclusion is, in addition to this, which I believe you can read, is really to focus on BRIPAN. I think you have a unique and a very amazing, opportunity to be able to impact on, our insolvency practices. First of all, let me extend, a very loud commendation to leadership here for getting, BRIPAN to be encoded, in CAMA. Today, your association, as part of those who certify insolvency practitioners, is there. Typically, with other associations, you have to have maybe a subsidiary legislation, but you have been able to get your association to be recognized in what is arguably the second ground norm, of our country. And kudos to you, leadership. But it goes beyond just being encoded in CAMA. It's now, being able to take yourself, to be able to influence and impact on what we have in terms of insolvency. Most often what you find is that, everybody, there's a race to wanting to bury an ailing company. But if we look at other climes, what really happens when there's default in terms of bonds is to first of all look at business rescue or corporate rescue. And I'm happy to see that, in your name, it starts first with business rescue. So it's not the insolvency part. And so the focus really should be on the business rescue. Because if you start going into the insolvency part where you have to go to court, where you have to file for a dissolution, we have a saying, people don't drag each other to court and then end up being friends afterwards. So not only would you get enemies for life, when you follow that path that CAMA prescribes in terms of insolvency as opposed to business rescue. So it's something that you need to refrain from, and when you have no choice, you actually go in that direction. But the business rescue, which is, more of what other climes have adopted, and I'm sure that you know this, I haven't studied with other climes, so I'm probably singing to the choir, but that focus must be maintained in terms of ensuring that all is done. And it's really to start to, do more around advocacy and influence the framework around business rescue. As it is right now, yes, quite a bit has been done, but there's more work to be done so that at the end of the day, what we have is bigger, stronger companies emerging out of adversity as opposed to companies completely going under. In addition to what is on the board, I just thought I should leave you with that. Thank you very much.
Thank you very much. Shall we put our hands together for him once again? Just very quickly, he started by telling us that bonds are like IOU, which are used to raise revenue via borrowing. Even though he entered the caveat by saying that he wasn't providing us with an advice, I'm sure there are a lot of takeaways from his presentation. He talked about the causes of bond failure to include poor financial position and cash flow, and other macro events such as recession or rising interest rate. He talked about some mitigating factors that we can bring in, which included enhanced disclosure and to strengthen bond governance and market surveillance, of course, which BRIPAN has a role to play here. The impact of bonds failure to include the market confidence, that will affect market confidence in such an economy. And of course, he tried to give us some remedies. But the most important thing he spoke about is the advocacy around the fact that the job of BRIPAN is more of, BRIPAN should carry out that advocacy to say that the job of our practitioners is business rescue to ensure we achieve better outcomes for a company that is in distress. I think that's the most important thing we should have in mind. Thank you once again. I'm sure there will be some questions at the end of the entire presentation. Very quickly, we'll go to the next presentation because of time. And that's on the taxation, the law and practice of tax collection in insolvency situations. Mr. Bidemi Daniel Olumide will be speaking on that. You'll begin to wonder why a business that is already going on that should be paying tax. And now when I think about that, I now look back and say even dead people pay taxes. You pay duties on the estate of a deceased person and the rest. So you'll be able to speak to us to give us some perspective on this. Mr. Bidemi, thank you.
Standing on the existing protocol. Good afternoon. As the chair said, I'm here to speak on how government collects taxes in insolvency situation, or how government should collect taxes in insolvency situation. What, however, I'm not going to be speaking about is whether government itself is solvent. That's a very important question. And you get to understand the importance of that question from the fact that perhaps oftentimes government's inability to fund its operations or fund the necessary goods and services that should be provided in society is perhaps the reason why some businesses are getting insolvent. So I guess with that point, perhaps we have something to discuss at the next conference. I really believe it's a valid conversation to be had as to government's insolvency itself. So to begin, I will be speaking generally, sorry, slide please. accompany it. In insolvency, we typically would say that government is a lawgiver. Government determines how the laws are interpreted. And oftentimes, too, the government is a creditor. Government is the one that is being owed. Much of my conversation this afternoon is about when government is being owed. Government being owed does not necessarily have to arise from taxation alone, even though taxation is the gist of my topic. Government being owed, of course, can arise from revenues and monies that are due to government as a result of the services or the services that it provides in society. So, let's narrow it down to government revenue arising out of taxation. Now, a conversation that also should be had, or perhaps we should be looking at, is, are we looking at insolvency? Are we looking at taxation-induced insolvency? Because it could be on the table that the reason, right, why the business in itself, and that was perhaps an aspect of the first, the topic I don't want to talk about, that the reason why the business in itself has gone into insolvency is also because of, payments of its taxes. It doesn't have all the liquidity that is required to meet the existing obligations as arising from its taxes. But in this case, what we're looking at really is government is a creditor, there is a tax obligation, and oftentimes, as would happen, there must be a default, right? So insolvency, you get into a state of insolvency, right, and then you're defaulting in terms of the payment, of your taxes, because you don't have that liquidity. So the question is, what does government, what rights inures to government, and how does it go about this? Now, it's, for those following the slide, I don't want to be caught up with 5 minutes, so I'm jumping the slides as quickly as possible. So I'm actually on slide 13, which goes to the gist of the topic in itself. Now, government's right to collect taxes, right, does not crystallize, right, until about 3 stages have been, undergone, or you've gone through those 3 stages. In other words, first, there must be an assessment of the tax. Some of the slides I skipped, right, really talks about the nuances of taxation, being that it is not born of the whims and caprices of anyone. It has to be by legislation. Government must have legislated, there must be a law, there has to be certainty about it. Likewise, if government is to say you are owing it, then it must have been able to correspond with you by way of a documentation known as an assessment. But it doesn't stop there, because part of your taxing rights, or your rights as a taxpayer, is to object to whatever government's assessment is an intrinsic right to the system. So you object, and if you disagree, or if the government disagrees with you, then you still have that right to go through the appeal process. Now, if you decide not to object, of course, your tax becomes due and payable. If you object and you go through the appeal process, then until that process is done, of course, there's some exceptions. Until that process is gone through, government's right to collect that taxes from the business, right, does not crystallize. You must go through that process. It's an expression of your right. So we say that that process itself, right, is statutory. So there is no favor being extended at any point in time to anyone. It's your right by law, and so you must extend it. At the end or the exhaustion of that process, then government can decide on what to do. The very first and the very popular one that we all, always akin to is the power of district. So in other words, it goes straight into it for the jugular destroys your assets, destroys your operations, and then with the hope of collecting its taxes or the monies due to it. But also, government sometimes undertakes court actions for the purposes of establishing even the debt in itself. It's not at all time that government must restrain. The power of restraint itself is very statute-based in the sense that it has to do with an interaction between government and the courts, working hand in hand before that expropriatory process, can be levied on you. Government can also go to court. Now, I call these simple, ordinary processes that we must be aware of. But now let's go into the core technicality of insolvency. Right, next slide, which talks about insolvency options and the major insolvency options, currently opened to us. Of course, with the advent of CAMA 2020, we have now left the liquidation-based, receivership-only based insolvency regime, and we now have more options, particularly, the mention of the two of the CVA and administration. Now, this gives businesses or this gives practitioners more options to restructure, particularly within the view of rescue, of the business in itself. So, an insolvency is called, the laws in themselves, I'm yet to see a situation where government is the one that's invoked any of this in itself, any of these options. So we assume that these options are invoked by a regular creditor. Where does government sit in all of this? Before now, we've always known that, or we're told that government, is preferred, by virtue of Section 657 of CAMA, but that has changed with 2020 CAMA. Now, where the law is abundantly clear by two provisions, as Section 207.4 of CAMA, and then Section 6576 of CAMA, that now prioritizes fixed charge holders above government. So right now, government sits second on the ladder of distribution. But that provision in itself, that Section 657, the Section 657 in itself, where particularly the provision that talks about how government is settled, also should require critical thinking or critical thought through by practitioners. It is not all the debt that is owed to government by taxes that becomes recoverable or collectible. You need to critically look at that provision. And if you look at it with its very winding, these are provisions that, since 1990 CAMA, you need to critically look at it and distill it. So that distillation, next slide, is what I've done on the next slide to say, how are those taxes valued? How are those taxes measured? What are the limits and extents of those taxes? It is not for the taxman, especially at the federal level and the state level, to come up to say, look, I have 6 years old taxes and then I want to collect. Now, you need to be careful that in almost all of the other insolvency options we have, administration and CVA, reference is still always made to 657. 657 is a winding up provision. But then, even the laws on administration still refers you back to 657 when it comes to distribution. You must respect that preference order. And again, in summary, government no longer sits as number one. Government sits as number two after fixed charge holders. And in government sitting as number two, it's not the entire ambit of what is due to government that is collectible. Now, some of the slides I skipped talked about the division of powers, all right? I didn't want to bore you with all that legal jargon. And that was at the local, the state, and the federal level. So what you see really is that for the local, there seems to be some preference as to the taxes that are collectible by way of that distribution, because it limits it to that tax having been due, right, and payable within the last 12 months. So with local government taxes, a lot of which are arising now. Yes, God will have it. Government doesn't need our money. They never came. And then I said, hallelujah. But then, that shouldn't be. Government should be interested. In actual fact, if government is interested, it could facilitate the process of the resolution of a lot of the insolvencies, that we have. But then later they wrote to say, oh, we want to come conduct an audit. And wrote that we want to conduct an audit for 6 years. But then, I'm faced with an insolvency situation. If I have to distribute, you can't even collect the money for 6 years. The money in question, I have to limit you to 1 year. So I also wrote back and said, fine, I don't even have the resources to undertake an audit now. However, right, this is an administration. You can't even make any claim now because of the moratorium, right, on your rights to make any claim against it. And perhaps my English was too much because I never got a response back. But then, I think the gist and the moral of it all is that the government does need to pay a little bit much more interest in this if it really wants to, collect its funds. And perhaps we could say that the rights of taxpayers, as it were, in terms of the practice of government, particularly in insolvency situations, is for government to say, even the guys who are alive, I've not collected my taxes from them. Is it the one who is at the throes of death that I want to now start chasing? Just one last minute, please. And I think it's just in policy consideration. If you remember those nudges I raised, and I think that is the admonition, and to us all as insolvency practitioners, that we still really need to revisit the question as to what is our central policy as a nation, as a people, as an economy on insolvency. We have legislations, we have administrations, beautiful, but we still don't have that singular policy statement, that singular policy framework, that singular body of nudges on how we treat insolvency situations generally, and of course now with taxation. Thank you very much for listening.
Thank you, Mr. Olumide. That was a very wonderful presentation. By way of recap, I'll say that what is started by telling us that it's the prerogative of the government to enact laws through the National and State Assembly as appropriate for insolvency and even tax collections. He spoke about the fact that it is important that we interrogate the fact whether the insolvency situation did not even arise from excessive taxes. And that when you are trying to tax in insolvency situation, you should be mindful of the fact that you cannot go back more than 1 year to 6 years. Of course, nobody will come to you to say, I want to do an audit. They will tell you we are doing investigation if they want to go beyond that. So I'm sure people would like to ask questions around that. And of course, he talked about the priority of distribution in the event of insolvency situation with the fixed charge holders now coming and ranking before taxation. Thank you once again. That was a very wonderful presentation. Now we're going to the last presentation for this session, and that is on financial literacy for insolvency practitioners. Since we're inducting new members into the body today, this is like BRIPAN 101 for you. So I urge everyone to listen carefully. It's like introducing you to what it's all about, what you need to be a qualified insolvency practitioner. So we have here with us Mr. Oluwaseyi Emmanuel Fayemi to do justice to that.
Thank you. Good afternoon, everyone. It's a great honor to be in your midst at this time. So we're doing this together. It's just the paper is about financial literacy for an insolvency practitioner, and it will be taken by my humble self, Oluwaseyi Fayemi. So we're taking us through the Nigerian financial market, which consists of the money market, the capital market, the pensions, insurance, and the major regulators in the market are the Central Bank of Nigeria and the Securities and Exchange Commission. The participators in these markets include the commercial banks, the finance houses, the microfinance banks, the FMDQs, the issuing houses, the brokers and dealers. And major instruments traded in these markets include treasury bills, commercial papers, equity, bonds, alternative investment, and mutual funds. So we're looking at the behavior of financial sector and performance. And we'll see there, as you could see on the screen, I don't know if you could see, but in terms of assets and capitalization, you will see that the banking sector takes about 51% of that of the financial market, while the capital market takes about 36%, pension takes about 11%, and insurance takes about 2%. So these are recent policies and developments in the financial sector. We have the RSA for mortgage, whereby you could use your retirement savings account balance to fund equity for mortgage, for residential mortgage, so to say. Then we have the currency redesign and cashless withdrawal policy, which is to discourage cash withdrawal and encourage a cashless society. We have the insurance coverage, which is to engage in sensitization program and expansion of insurance products to agri sector. We have the Naira there, which is a central bank digital form of currency, which is also a legal tender. And this is just to cure the appetite for virtual currency and to also deepen financial inclusion. So we have the new capital market products, which includes the crowdfunding, exchange traded derivatives, warehousing, and collateral management. We also have the LT 200, which is aimed at driving about 200 billion from non-oil sectors for the next 35 years. So we go quickly to what is financial literacy. It is the possession of knowledge and skill by individuals to manage financial resources efficiently to enhance economic well-being. So we look at why is it important for us to have financial literacy. And we could see that people who are financially literate are less vulnerable to financial fraud. So it means that you could be able to differentiate between a good or a bad investment. You know when to go into an investment and when to probably exit. So it helps in achieving various life goals, which includes savings for education, savings for retirement, or for a business purpose, as the case may be. So it also opens the doors for passive income. It helps you with your budgeting. It helps you to reduce your spending strategies, and also help you to make the right investment decisions. So the knowledge of financial literacy is also going to help you to protect you against debt and bankruptcy. So it means that if you have a good knowledge of financials, it helps you to be able to look at the basic ratios or look at the basic pointers to look at before you get to a level whereby it degenerates to a situation of debt or bankruptcy. It also helps in the saving culture. So you know that if you need to spend in the future, then you need to save today. So we have different components of financial literacy, which includes the financial knowledge. And this is just an understanding of the financial concepts and procedures, which includes budgeting, compound interest, financial planning, and all of that. And the application of this knowledge in solving financial problems. So we talk about the financial skills, which includes the knowledge and understanding to manage unexpected or unpredictable situations or unpredictable financial situations in the future. And this also helps you to convert your benefits and opportunities to one's advantage. We have the financiality tool, which is your willingness or readiness to use this knowledge in all various financial situations. We also have the behaviors, which is behaviors in specific financial markets that you find yourself. So we look at the level structure of financial literacy in Nigeria. And as you could see there, we have a low capacity of financial literacy in Nigeria. And as it's been displayed there, you can see that 1/3 of the country is low in financial literacy. So this is just to give us additional information about the depth of the banks and on the unbanked and the financial excluded within our sectors. And as you can see there, the adult population of 18 years plus, which is secondary school and above. We have about 58.9 million within that bracket. And you can see that we have a 68% in financial inclusion. And you can see Malaysia topping the charts, China, and you can see Nigeria at 50.87. We are not the worst, but a little bit above Egypt at 33.79. So insolvency and its practitioners. Insolvency is when an individual or company cannot commit to their financial obligations of paying the debt as and when due. So why insolvency practitioners are usually accountants and solicitors who act as trustees in insolvency cases where they control and sell an asset. So why financial literacy is needed for an insolvency practitioner? It gives proper guidance on the management and control of risk. It enables the insolvency practitioners to guide against debt and obligations. It also helps the insolvency practitioners to give the right advice to his clients. So we look at the role of insolvency practitioners, and these are roles that most people are familiar with. Insolvency practitioners hold different roles depending on the insolvency case. And you can see in they act as liquidators, they act as administrators, and they also act as nominee and supervisors. But I don't want to waste much of our time on this because I know most of us are familiar with this already. So go to the responsibilities of insolvency practitioners, which includes providing advice, negotiating with creditors, selling a company's assets, reporting to creditors as and when needed, investigating company activities to see what has actually gone on before they got to that level, distributing collected money to creditors and other relevant stakeholders. So we look at the connections between financial literacy and insolvency practitioners. So insolvency practitioners gives financial advice to their clients on how to be financially literate. Insolvency practitioners give financial and technical advice on financial principles and concepts, which include some of the things I've mentioned before: budgeting, financial planning, compound interest, debt management, and profit-saving techniques. So they also give financial advice on the importance of the understanding of the value of money and the principle of wealth management. They also engage in investment management on behalf of their clients. So we look at part insolvency and full insolvency. So part insolvency is when a company is unable to pay its liability in full, while full insolvency is when the company is in financial distress and it cannot pay his liability in its totality. And there are ways to avoid this. There could be reduction of overhead costs. You could look at your line cost and see which of it is contributing, which of it is affecting your bottom line, and you could take care of them as the case may be. You could also seek expert advice. If you find yourself in an industry or you find yourself laying your hands on some financial documents that you don't have an understanding of, you could seek expert advice. it's also important that you maintain accurate financial information. There's also you need to also maintain accurate analysis of cash flow. You need to be able to analyze very well the money that comes in and that goes out. And it's also important for you to also have a review of your financials, which is consistent auditing of financial information. So steps towards improving financial literacy in Nigeria. So there's need to increase consumer financial literacy to improve the literacy penetration ratio. Engagement of Nigerian youth to create more active financial industry participation rates. As we all know, women are more handlers of money than men. So women need to be targeted because they are more reliable borrowers of funds at the micro, small, medium enterprise levels. IP needs to be financially literate and transfer the knowledge to their clients and the public. So these are just some disciplining insolvency practitioners and their management of funds. Insolvency practitioners could be checked by ensuring that the accounting reporters are not permitted to become receivers and liquidators, by ensuring that all stakeholders are had a meaningful say in the insolvency matter. There should be routine independent audits of the insolvency practitioner accounts, bills, or costs. Insolvency practitioners should be supervised by a committee representing the creditors of insolvency business, and stakeholders should have access to their files and working papers when the need arises. There should be equality, democracy, fairness, accountability should be the guiding principles of every insolvency practitioner. So in ensuring transparency and accountability, there are some accounting bookkeeping tools that one could use. And we just have 3 here, which is an IPS Cloud, which is a case management software to support the restructuring process and cost reduction base. There's also the creditor portal, which allows stakeholders to submit claim, assess documents, and vote on insolvency cases. There's also the Turnkey IPS SQL, which is a trusted case management software across the globe, and it improves case management process, external communication, and the way you work while ensuring compliance with the latest regulation. So this is my last slide. I know my time is up. So regulations of insolvency practice in Nigeria. The insolvency industry needs urgent reform. The ideal position would be to delegate the whole conduct of the insolvency process to an independent, non-profit-making organization. The profit motive is responsible for a large number of abuses by insolvency practitioners. The insolvency industry needs to be regulated by a regulator, an insolvency commission that is independent of the insolvency industry administrative association. The commission should be able to suspend or withdraw licenses and levy unlimited fines for non-compliance with its rules. It can also mount civil and criminal proceedings where necessary. All licenses will be required to publish meaningful information about their affairs. Thank you all for listening.
Thank you once again. Shall we put our hands together for him once more? When he was starting, I said that this is a lecture that inductees should pay attention to. He spoke about financial literacy as the possession of the knowledge and skill in order to effectively manage financial resources. He touched on the importance of such knowledge to enable IP, that is our practitioners, to provide financial advice and guidance on management and control of risk. I think he touched on a very important aspect, which is the ethical issues, that beyond the fact that you issue licenses to practitioners, that you should actually check the conduct of such person, even though he talked about an independent body that I look into that. I believe also in self-regulation. I'm sure a lot of our council members here will take you up on that during the question and answer session. But the most important thing is that from the 3 lectures we have listened to, one important information that we can all pick out from here is that insolvency is not about killing the undertaking. It's about rescue. It's about bringing it back to life. And that reminds me of one story that I used to. There was one old man in a village, about 90 years old. And there was this young man who was a coffin maker, those who makes coffin for burying dead persons. And each time this boy is passing, the man will say, "How market?" And the boy simply answers, now they look. That means if you don't die, we won't be able to have business. So for us, we shouldn't look at it like we're not trying to kill any business practitioner. We should be looking at rescue. But the ethical issues that you raised, I think we should pay very close attention to that. We should look at how to discipline the erring members beyond the fact that we have issued licenses. We should check on what these people have done with the licenses issued. So the various speakers we address will be ready to take questions. We'll take a few questions because of the time. And after that, we'll round off. Questions, please. I know that it's time for lunch, so it will be very difficult to have plenty of questions at this time. Yes.
Good afternoon, everyone. My name is Chiwe Chiwete. I run a law firm called Epic Legal. First, I'd like to say thank you to the speakers for the insightful presentations. And just to add, to say something, I want to add something, particularly with respect to tax. As insolvency practitioners, it's very critical that you understand where the tax authorities are placed. And you also understand that when you're having any form of collective proceeding, whether liquidation, administration, anything that pull creditors together, you understand that the tax person is a preferred creditor. Before now, people used to interpret the old 495 or 494 to say, oh, the preferred creditor or the tax authority is the king. But that has never been my interpretation, because that section has a subsection 4 that says so long as the assets are insufficient for the general creditors, that the preferred creditor will rank above the floating charge holder. So that tells you that the preferred creditor or tax authority has always been the second place. So the reason why I'm making this comment is because even after liquidation or administration or business rescue, whatever you're doing, the tax authority can decide to come after you if not properly handled. I had an experience recently. There was a liquidation I handled, and a few months after that, I received a call, and of course, the tax authority said they wanted to meet with me and find out how the liquidation process went, because they didn't have, the company was owing them and all that. So, luckily for me, all through the process, although it was a members voluntary winding up, but all through the process, I had all the documents. I advertised for proof of claim, and specifically in line with the way I do my insolvency practice, I write to tax authorities. I wrote to them, and I said, this company is in liquidation. If you have any claim, come forward. So what I did, I just said to them, before we propose any meeting, I'm just going to send you the documents. Then review the documents and let me know if there is any need for the meeting. So I sent them the notice of publication. I sent them the letter specifically addressed to them, and they acknowledged. And they didn't get back to me because, of course, they looked at the documents and they didn't have anything to say. So obviously, the tax people, they are not even sure where they are placed in terms of what they are entitled to when the company is insolvent. I'm surprised they are not here, and I think one of the things we'll take from here going forward is the possibility of engaging them to know where they are positioned in terms of insolvency, and the need for them to always follow up, engage somebody to always go through the dailies, and also engage with the insolvency practitioners on how to get your...
Thank you.
Good afternoon. My My name is Foluke Akimolado once again. My question has to do with tax as well. How do you tax a company that is insolvent? If at the last accounting year or the financial year, it's most likely not going to be a going concern. So what profit are you computing and then paying tax on? Thank you.
My name is Sidney Chukwukel, Resource Matrix Forensics. My question goes to the person that educated us on academics. What is the import of the law? Because the challenges in this country is that the law appears, one, to be loop-sided, protecting the debtors. Then another thing is that the law appears to be relaxed in helping to manage the insolvency situations, because they seem to come after the event, not before the event. How does the law protect even the tax authorities and banks and the creditors, from knowing when or making them to be updated on when the company is going to, when they are having issues and challenges? That's my own question. Then another experience I needed to share, that I could remember in the beginning of my career, there is particular lady in Taiwan, and he told me that she was the father's interpreter, that in Taiwan, if you go on self-liquidation, if you are owing any company, if you are owing any financial institution, a must that you go to prison if you are unable to pay. So that puts everybody on the toes not to owe, or if you are owing, you manage it effectively so that you cannot easily go on liquidation. But in Nigeria, you see one person owing, working in 5 companies and owing about 10 banks, and nothing happens. Meanwhile, it's being celebrated as a celebrant in the country and having parties, throwing parties everywhere. So what is the import of the law regarding this? Thank you.
My name is Bolanle Alao. Regarding taxation in insolvency, my advice to the insolvency practitioners is that you should engage the services of a good tax consultant, because there are a lot of technicalities, and if care is not taken, you won't be able to concentrate on your own assignments. Unfortunately for us, the tax authorities, what they want is what they want. They want to meet the targets. They want all the revenue. So all this, even before they listen to these laws, and at times they will even put your letters by the side and start coming, doing all. So get a good tax consultant. It is very important. Thank you.
Any other question? Okay, we have a question here. Here.
Thank you very much. I'm not speaking for the tax authority, but we need to understand some principles that tax authority work with, and there are also laws that we, as lawyers and practitioners, we are supposed to be familiar with. So the tax authority does not raise assessments that is frivolous, particularly when it comes to liquidation, insolvency, insolvency generally. There are principles that have been stated in the law which needs to be followed. Of course, a lot of us as practitioners, we want to play around it. We want to see if it is possible not to inform the tax authority and quietly, particularly when it comes to voluntary liquidation, and just close your assignment. But there are provisions. I know that Olumide spoke about tax, and he was emphasizing on the last 12 months provision, which is specifically for liquidation. When it comes to all those administration and CVA, the company is being run as a going concern, and therefore all the provisions of the laws as far as tax is concerned are still applicable. And you should file, the company is expected to file the returns as a when due, as a practitioner or as a liquidator or insolvency person. if you are deemed to step into the shoes of the company. Okay, and therefore all of the responsibilities that are on the company as a going concern is now on the liquidator, is now on the insolvency practitioner, and all of those provisions, particularly as it has to do with transaction taxes, that it has to do with disposal of their assets. You know, as a company, you don't reckon with capital gain. It is possible there may just be capital gain on the disposal, even as a liquidator. So all of these provisions are things that you must take into consideration. Sometimes you hear people speak as if tax is just there to come and do what is not right. It is the provision of the law that they are trying to comply with. Thank you very much.
Any other question? Okay, the panelists are going to address the various questions, but most of them they came as comments, which I think we've already taken in. I know the gentleman at the back that said that the law seems to protect the debtors. I don't think that's correct. I don't think the law protects debtors only. It protects everybody. All you need to do is to get a very strong solicitor to go after the debtor. So I just felt I should just correct that one. But for the other, I think it's the taxman that has most of the questions that we got here.
Hello? Okay. So very quickly, I think let me take it from the rear, and just to re-echo Mr. Folorunso. And I think just also hard for insolvency practitioners that oftentimes taxation is not just about payment of money. It's also so much about rendering of information. Information that the taxman also needs. We call it returns filing, oftentimes, most of the times. So as an insolvency practitioner, just don't think about the money. Also think about the obligations, right, about rendering information to the tax authorities at when due. And I can give you a very quick insight to how the tax laws work. Oftentimes they're not. Much of the revenues that government proclaims that it's getting from taxation is actually getting from penalties and interests for failure to adhere to some key principles. Failure to file returns, the penalties and the interest starts accruing. So when they tell you they've collected 10 trillion, they've collected 8 trillion, question is it really from economic activities or as a result of penalties and interests? As a taxpayer, you must render that information. Interestingly, and in tax practice, like we say, it's not so much about you owing government money. That is a problem. More often times than not, the problem is you not even knowing how much you owe. The two different conversations. I'm not going to run a business and run the business into the point of illiquidity because I want to pay government. I can have conversations, and just like Mrs. Alao said, that's where tax practitioners come to play. A tax practitioner stands on your behalf, speaks to government, the rules are there. I am owing this, I would pay. In actual fact, rules on instrumental payments and all of that are rife. You could employ them, have conversations with the tax controller and all of that, and put things in place. Because like I give examples of for young entrepreneurs, if I have money to pay to government and I have salaries to pay to my personnel, I'm not going to say yes, so I'm not put on the record by the tax man. But we know the practical approach we will take. So, again, tax is not just about payment of money, but also on the rendering of information. You do need a good tax practitioner working with you. And good tax knowledge, I think, is something that perhaps at BRIPAN we find a way to infuse into the curriculum and all of that to enhance the experience of insolvency practitioners. To Mr. Lau's question, which is about the tax authorities misbehaving, I think I like to always drop this here whenever I speak at fora, right, as to the extent and the limits of our administrative law. I think administrative law is a fundamental aspect of public law that perhaps has not really been well upheld in our society, and that's why people with delegated powers, either delegated by the legislator or delegated by the executive powers of the governor or the president or the governor, misabuse those powers. There is nothing like absolute power anywhere. I mean, I like to quote this very important philosophical construct by Professor Frank Scott, which says the foundation of any modern society are these two things. One is freedom, and that is that the individual is free to do anything except there is a law that says he should not do it. In other words, freedom is the rule. Restriction is the exception. A law must say don't do it. Only that which is prohibited is illegal. There's a converse to that rule. And that converse is this. Nobody exercising public power or public authority can do anything except there is a law that empowers him to do so. In other words, restriction is the rule. Exercise of power is the exception. Which means all our public officials, public officers must always reference a power, a law that empowers them to do whatever it is they do. Not doing so is to infringe on my fundamental rights as to freedom. So very important. So if you meet a taxman and the taxman is speaking, the question is you have to go back to the tax laws. Where is the power that allows you to do this or not do that? I think it's very important. And to the issue of protection, I agree with you to an extent, and I think it goes back to that question I raised. What is our policy around on insolvency as a country? It needs to be documented. It needs to be explicit. Of course, it's going to take a lot of thinking and whatever. Is it protectionism? Is it a no-fault rule that, look, when you're insolvent, it's your adventure in entrepreneurship, and you've become insolvent, so there's nothing we can do about it? Or is it one that allocates responsibilities to people who owe themselves out as entrepreneurs to say, no, the society is just not going to forgive you? Why there is no fault, but there are some certain things that needs to be done. And I think the issue of timeliness in resolving insolvency issues come to play. A situation where an administration, or in my case here, is extending past a year because some shareholders just sit very pretty and the society is not, the laws or the policies or administration is not forcing their hands to say there are creditor rights at play here. There are people who have borrowed money. My granny will say, sorry, I'm Yoruba. My granny will say, Owo alata, owo niyo. Simply mean somebody is out there who's borrowed money from different places, right, to provide you goods and services. Now you've run yourself amok into insolvency, and you just feel pretty. Sit down there. You don't want to resolve their issues. You do not want to pay them. And society, everyone is looking at you that, oh, it must be forgiven. It's just an adventure in entrepreneurship. We have to go back to policy. And lastly, the question of taxation of an insolvency company. If you are in an insolvency situation, just like a prof said, Mr. Forlon should say, if you are in an insolvency situation, does not mean you do not comply with your tax obligations. Reference to section 657 is on distribution. Distribution, we call it distribution in administration. And in administration, and even in administration, Professor, even in administration, it still refers back us that whenever there's going to be a distribution, we have to apply the principles in 657, which is strictly liquidation. So, thank you so much.
Thank you. I think our time is up. The only assignment remaining for me is to thank the panelists for a job well done. I'm sure we all agree that they've done justice to the topic. So shall we give them a round of applause once more?
sir.
Please permit me to invite our immediate past president, Professor Fidelis Odita, KC, SAN, to please come and present plaques to our speakers and the chairman for this session.
Mr. 2, the chairman, on behalf of BRIPAN, I thank you for moderating this session so efficiently and effectively. Congratulations.
Yes. Oga, the bondsman.
Where is the man who was telling us about? All right.
The representative of it.
Okay, yes, I know Mr. Jallo, obviously. Yes. But he was a very able representative. He presented his paper very effectively. I thought he was just going to rabbit on bonds, but he eventually got there and told us about insolvency issues affecting bondholders, bondholder committees, and so on. Very well done. Thank you for a very great presentation.
Thank you very much.
On behalf of BRIPAN, thank you. Right. Okay, this is the debatable first administrator.
Agreed that his own has gone past 1 year.
And there might be others that we have. We haven't collated information yet. But yes, Mr. Lumide, thank you for your very excellent presentation and for informing us about the implementation of the rescue provisions of CAMA, and you had the distinct honor of being the first administrator, and it turned out to be the unfortunate Morehouse Hotel. But what is unfortunate for one person, I'm sure it was fortunate for you. So on behalf of BRIPAN, I thank you very much for your very entertaining and well-informed presentation. Congratulations.
Thank you, sir. Thank you, sir. This is a picture, sir.
We have one more. The man who was talking about financial literacy. Yes, where is the financial literacy man? Yes. Thank you very much on behalf of BRIPAN for your very informed presentation on financial literacy. I thought also that you should have told them, because there's so many lawyers here who can't read a balance sheet. And therefore, when we're talking about financial literacy, we also mean ability to read and interpret balance sheets. Very important. All of them here, they want to be appointed as insolvency practitioners, but when you give them a set of financials, they don't know what is cash flow and they don't know what is balance sheet. I thought you would help them. Maybe next year we'll bring someone to come and tell them. That's why they shouldn't be appointed. Yes, that's true. The bean counters are better at such things, yes. So on behalf of BRIPAN, I thank you very much for your contribution to this excellent session. Well done. Thank you. Mr. President?
Yes, please let us have a group photograph with this panel.
All right. Ladies and gentlemen, if you look over here to my right, you'll find a really huge, I think it's a 70-inch smart television set and a washing machine. Just these two are just tip of the iceberg of the prizes that we have to give out tonight. Now, I have been told to ask us to please ensure we return back in the evening. But I am very sorry, I have to apologize to the people who sent me. You know, I'm just a messenger. But I want to say, please don't come back. The fewer we are, the better my chances of winning this raffle. So I'm not going to beg anybody to come back, because I hear that they have other things to give out as well. I hear they have, I don't know if is it a land title deed or something, a document for a land or something that they are giving out tonight. So ladies and gentlemen, if you like, if you don't come, you miss. It's better for me. The fewer we are, the more my chances, all right? But ladies and gentlemen, this is just to encourage us to ensure that we come back later in the evening for the All right, so ladies and gentlemen, right about now we're going to have the debate. It's usually very interesting debate, and to help us through the debate session we have Ms. Efosa. Efosa, may we have you please? I'd like us to please sit down, pay close attention, because All right, so ladies and gentlemen, please put your hands together for Ms. Efosa as she takes on the debate session.
Thank you, special MC. Please, you kindly indulge us again for this last session, is our closing session. And we have the young practitioners debates. You would agree with me that the last session helped to set the tone, that as insolvency practitioners, we should think of rescuing the business rather than killing it. So we should think of rescuing it first rather than killing and burying it. So for us this evening, or sorry, still afternoon, I'm sorry, we have young practitioners who are very passionate about this position. And David Ekanem agrees that the law should compel creditors to explore rescue before liquidating failing companies, while Jennifer is going to oppose that motion that the law should compel creditors to explore rescue before liquidating failing companies. So I'll now invite our debaters for this session, Jennifer Omone, who is an associate of Babalaki & Co. Please put your hands together for her.
Please put your hands together for her.
Then we also have David Ekanem, who is an associate of Stream Swords and Co., who is going to argue for the motion that the law should compel creditors to explore rescue before liquidating failing companies. So this is just going to be a light-hearted debate. We are not expecting to get winners or losers, but maybe we may just have to toe that line. We've decided to choose from our audience informal judges in our midst, erudite practitioners and scholars. We have our immediate past president, Professor Fidelis Odita, KC, SAN, who will think should help us in taking on this role as an informal judge. Thank you. So now I yield the floor to our debaters, who would have first 3 minutes, 5 minutes first, then your rebuttal for 3 minutes. So I'll start with you, David.
Thank you very much. Distinguished ladies and gentlemen, panel of judges, Lenny Silk, sir. My name is David Ekanem, as said. Okay. Sorry. Yes, I am here to support the motion that the law should compel creditors to explore rescue before liquidating failing companies. Okay, thank you. So, because I am owing you does not mean you should kill me. I mean, all life matters. Artificial life matters. Natural life matters. And even Nigeria is owing. So imagine if Nigeria is owing China and China wants to come and wind up Nigeria. I don't know, it will affect all of us here. But let's move on. So prior to the KAMA 2020, failing companies or financially distressed companies were compelled to face, for the purposes of this debate, please, liquidators are my friend, but I might have to say one or two things. I'm going to have a name for the liquidators. I call them the Grim Reapers of corporate entities. They were compelled to face the Grim Reapers of corporate entities who would strip assets of companies just to satisfy the creditors that appointed him or her. Now, we know the purpose of law is to identify the interest, balance the interest of both the debtors, the creditors, and even the company. And we have, and by virtue of KAMA 2020, which we term it as a business-friendly legislation, KAMA introduced and revealed to us business rescue strategies and mechanisms. But the problem is that KAMA left it at the whims and caprices of the creditors, which means they can decide to dismiss the scheme that may be brought up. And in Nigeria, and currently, considering the situation of things, a patient dog eat the fattest bone is a problem. We don't follow that anymore. So why should the law compel creditors to sign up for business rescue? Number one is for preservation. Business rescue tends to preserve the value of company assets. Now, in that instance, we know that liquidation, once a company is in for liquidation, the assets of the company are systematically underpriced. Everybody wants to just do away with, give me my money, your money, or my money or your life kind of situation. But I'm going to make sure I collect my money. That is what happens. And no matter how a liquidator or the hangman decides to procure this asset, it's going to be underpriced. And what value does the liquidator now have? Because from the proceeds of the liquidation, you have to first of all settle administrative expenses. And imagine that the asset is not even sufficient to even satisfy your debt. How much do you now have? How much is remaining for you? And by the introduction of the innovation made by KAMA, you have to make priority has to be given to the employees. They have to eat, they need their salaries. And at the end of the day, you are left with little. The value which you invested is even lesser. So, but in business rescue, you have the ability to negotiate, re-strategize, be part of the conversation, and build a maximized value for yourself. Secondly, job preservation. We all know that by virtue of the fact that a company goes into liquidation, that company is going to cease to exist upon winding up. And the case of CBCL Limited versus Okoli, the court said that once a company is wound up, it loses its personality. It ceases to exist. And it affects the employability because people will be rendered jobless. And how does it benefit the creditor? When people are jobless, you don't have a company running, giving you a particular value, or you cannot even maximize the value of the company. And we know that the essence of business rescue is to make sure that the survival of a company goes beyond a going concern. And it helps to sustain the value of businesses, secure employment, and maintain stability in the economy. Once the company is wound down, no jobs, everything loses. The creditor loses and gets a crumb of what is remaining. But in business rescue, it tends to preserve the job, tends to preserve and make value and maximizes economic stability in the country. According to the World Bank data ranking, in terms of time, cost, and outcome of resolving insolvency issue, Nigeria is ranked 145 globally and 31 in Africa. And even when our speaker on financial literacy was speaking, we saw where Nigeria was always second to the last. What happens to the top? So we need to invest more in business rescue, which is one of the criteria of international best practices. And countries like South Africa, UK, US, Wales, and Australia, these countries that are making use and exploring business rescue, their economy is doing well. Potentials for turnaround. Business rescue can give the opportunity for a company management and stakeholders to implement a turnaround strategy by way of restructuring, renegotiating contracts, seeking new investment. Indeed, the patient dog is the fastest bone, because once you are able to, a company in business rescue can become a very viable and become economic stability. Thank you very much.
Jennifer, I'm sure you do not agree.
Of course
so
I don't.
Let's listen to you.
I strongly disagree. I object that the law should compel creditors to explore rescue before liquidating failing companies. I mean, imagine a country where the law forces and mandates creditors to explore rescue or restructuring of a company. What I see is a country where the law tramples down on healthy and reliable lending practices and creates moral hazards. Good day, ladies and gentlemen. My name is Omohe Jennifer. I am here to strongly oppose the motion that the law should compel creditors to explore rescue before winding up a company. And my reasons are not far-fetched. One, rescuing failing companies is very complex. It is not an easy process. Let's take, for example, company voluntary arrangements. There are a lot of things that goes on with company voluntary arrangements. And if I implore you now to search on Google how long it takes ordinarily, not even for the complex situations, ordinarily, how long it takes to complete company voluntary arrangements, you would see that it runs between 3 to 5 years. I mean, why should creditors be made to wait this long before recovering their investment from companies? You also have to consider the cost of restructuring or rescuing a company. It is not cheap. It is very expensive. And now imagine the financial implications of restructuring a failing company, outweighing the potential benefit of even embarking on that process. I tell you, it is a journey of no return. Okay, let's also consider the fact that there are low guarantee of success. The fact that you want to exercise or explore restructuring of a company does not mean that it will be successful. Imagine forcing creditors to restructure a company where the likelihood of success is very low. This would result in a protracted dispute between the creditors and the companies, which may go over for years and years, which would even make it lengthier for creditors to recover their investment from companies. Okay, I'm going to speak about the diverse interest of creditors. Creditors have diverse interests. While some creditors want to wind up the companies and minimize their losses, there are other creditors who would say, okay, let's go for restructuring. But asking the law or bringing about a law that would compel these different categories of interest to explore a compound solution, which is restructuring, is rather unreasonable and unacceptable. It is unsuitable. We should be able to balance the interest of creditors against the fair and effective resolution of insolvency issues. I'm also going to speak to some of our insolvency practitioners here. You know that some of these companies, they are not transparent. They have the money. And not until you institute a winding up proceeding against them, you would see them hurrying, going back to pay their debtors, because actually, they have this money. Okay, I'm going to be speaking to David, who said that winding up would result in lack of jobs and is it diminished value? I didn't really get that part.
2 minutes more.
Okay, yes. If you would ordinarily change your job when you don't like the pay or they are not treating you well in a company, if the company is being wound up, you take your skill to another company. It is simple, and the country moves on. No harm is done to anyone. Lastly, I would want to talk about the point of feasibility. It is not always feasible. Sometimes winding up is just easier. Let's wind up this company and have our money rather than go through the rigorous process and complex process of restructuring the company. Please, I don't want, if you're a creditor here, I'm very sure that you would be happy to rather wind up the company than go through 3 to 5 years of restructuring of a company. I mean, okay, lastly, I want to talk about the fact that companies really should be the ones that the law should compel to make sure that they pay their debts on and when due. When do you say a company is failing?
1 minute more.
When do you say a company is failing? A company is failing where they are unable to pay their debts or meet their debt obligation. And there are a number of factors that result in a failing company or a failed company. One, poor leadership. Why should creditors be made to take the hit for poor leadership leading to the failure of the company? Secondly, you have things like not going with a business plan or going against the advice of experts. If a company fails as a result of these issues, I wonder why the creditors should be made to take the hit or the fall for that bad decision. Thank you.
Thank you, thank you, thank you. David, I'm sure you give a fire back. So your rebuttal.
Yes. Thank you very much. I'm going to make some rebuttals to what my friend has said, my co-debater has said. She mentioned healthy, reliable practices. I have not seen how healthy winding up how healthy it is when it comes to winding up, because at the end of the day, the company, a financially distressed company doesn't mean that the company is going down. It just needs a push to come up, not because of one thing. Let's take, for example, COVID-19. Who knew that COVID-19 would come up? A lot of companies went down because of COVID-19, and we did not have any business rescue strategy. So, when it comes to business rescue, there are times for this is a chance for a company to re-strategize and come up with something that would help it to come out of this financial distress. It is very complex. It is not. Various jurisdictions, South Africa, for example, by virtue of the Companies Act 71 2008, says that the first thing a company should look out for, where it is financially distressed, is business rescue, which will take 3 months. And it's by way of bring up a business rescue practitioner, like everyone seated here today, which will help to bring back the business, bring back a financial distressed business back to life. And guarantee of success. This is what South Africa is doing. Out of 4,980 companies that were listed for business rescue, only 519 were listed for liquidation. You have seen the level of success that has made for other jurisdictions. And balance of interest of the company. That is what the law is doing.
1 minute more.
Okay, thank you. The law look at the interest of parties. A financially distressed company is not that the company is going to die. Even when we are sick with malaria, we know we are going to be healed by taking medication. Same thing happens to a company. Even when we are going for surgery, like a human being, we know that we are going to succeed. We pray to God. After all, we believe in miracles, like Nigerians that we are. So how much more a business rescue? It works. And for feasibility, mismanagement, that is why we need business rescue as #1 priority. Not for you to end a company, but to help it and restore it to its proper glory. Thank you very much.
Thank you for that, David.
I'm back again. We should not forget that not all failing companies can be rescued. Some of them cannot be rescued. So I don't see the reason why we should allow creditors go down that lane, which they would not even be able to walk back out from. Okay, statistics have shown that 80% of companies are successful, while 20% of companies are failing. Statistics have also shown that even in Nigeria, new companies are launched every year. I think in 2022, it was about 104,000 companies thereabouts. If some companies fail, new companies are coming up, people will get jobs. It will also result in revenue for the country. Lastly, I want to emphasize the fact that compelling creditors to explore restructuring before winding up a company is an unfair restriction on the ability of the creditors to exercise their rights to the legal claims to the legal claims over the asset of the company in order to recover their investment. Because this is it's an unconventional debate and it is lighthearted, I would want to end my debate by singing this song that is it Ikemowo Ukwa sang I don't know, I was really little then, but when I was thinking about this debate, it made sense to me. Agreement is agreement, yo. Agreement is agreement, yo. You don't reach for settlement. You come, they tell me nonsense. Agreement is agreement, yo. Please, creditors should be paid back their investment and not allow the law to restrict them into a process they don't want to follow. Thank you.
Thank you. I really didn't know we'll get into a choir session this afternoon. So I'll hand over the microphone, please. Can someone hand over the microphone to Professor Odita to give us his comments as an informal judge? And I think I want to be impartial here because I've picked a male. I want to be gender sensitive and pick Mrs. Justina Lewa to give her own comments when Prof has given his. Thank you. Come as an informal judge, just give us your comments concerning the parties, the debaters.
Agreement is agreement. Except that I didn't quite agree, but I thought it was a very lively debate. And I thought they raised very interesting and important points. Mr. Kanem, for example, emphasized the need to preserve businesses which are distressed, and also by giving us the illustration of the impact of COVID-19, he emphasized the involuntary nature of certain distresses that companies face. It's not just because the directors are incompetent or because they are fraudulent or the management has not done what it should do. Sometimes it's just adversity. You find yourself in an unfortunate but helpless position. And that in such cases, the law should help them by compelling creditors to exercise their rights with constraints. Ms. Omona, on the other hand, emphasizes the sanctity of agreements and invokes Nkem Owo, agreement is agreement. And of course, I think she presented her case as an extreme. She's not saying, as I understood it, that companies should not be rescued. Her objection is that they should be compelled to explore that before anything else. I'm sure she doesn't want every company which is distressed to be dismembered. But also, of course, I think because she's a young practitioner, she doesn't yet know that liquidation is not quite as simple. And that the fact that creditors are given the right to petition for winding up doesn't mean that they will get a winding up order, because as experienced practitioners know, the problem in Nigeria is not access to the courts, it's exit from a court. So when you get there, you get torpedoed, whether it is you're winding up, you might find that for 5 years, you are still trying to wind up. Whereas, of course, if you were more sensible and you agreed to restructuring, which is a more consensual process, you might have made more progress. But I thought the two debaters debated excellently and showed that the future of BRIPAN is still very bright. Thank you very much.
Thank you so much, Prof. So please give the microphone to Mrs. Lewa.
Okay, so for me, it was quite interesting and insightful. We heard both sides, one for and the other one against But both of them are quite useful because as practitioners, we will be faced with both positions. Yes, we will be faced with both positions. So I agree with what the Leonard Silk has said. So I won't go about repeating all of that. But business rescue is helpful. It is an option which we must look into. Before you go into insolvency proper and just liquidate the company, you as a practitioner, take a look at what is before you and then see if you can exercise that option. If it is not feasible, then you can move on to insolvency, liquidating the company. 2, each scenario is different. In some places, you will need business rescue. Others,
thing that we are doing in BRIPAN, which is empowering the youth and also creating mentorship programs. For us in BRIPAN, visibility for youth is important. Also, knowledge sharing opportunities, opportunities to have practical experience is very key. Right now, we are collaborating with Insol on a program with Insol calls Insol Future Leaders Program. I'm sure some of the participants in that program are here in this audience. This is a program that BRIPAN would mentor 20 people, 21 people every year. And 4 BRIPAN firms would undertake that mentorship program one every quarter of the year. So 4 times every year, we have a BRIPAN firm hosting 20 young practitioners in their office on soft skills, practical issues, so as to enable them have a real feel, not just technical, because we have to understand that people want to know what actually happens on the field, what actually happens when a receiver goes into a company, what happens with a liquidator, how are administrations undertaken. So these are opportunities for us, for young members, to get practical skills. Because of the limited space, at our last membership night out, we inaugurated our own local Future Leaders Program. It's called the BRIPAN Future Leaders Group, and it is chaired by Ms. Efosa Ewere. Ms. Efosa Ewere is the chair. Members of that Future Leaders Group, if you are here, please raise up your hand. Members of that group. There are only a few of us here today. Okay, thank you very much. I want to thank the firms that have agreed to also collaborate with BRIPAN on this Future Leaders Program. Professor Bankole Shodipo, SAN, I believe is here, Gio Shodipo and Co. Thank you very much. He has even agreed to be the first host of that program. Femi Fajolu, thank you, we appreciate you. Shola Oyetayo and Co. Thank you very much. Mr. Shola Oyetayo is one of our past presidents. SIAO, Chartered Accountants, Mr. Abiodun Ariyibe, he is our second deputy vice president. His firm has agreed to host us. Ayodele Akitunde and Company has also agreed to. Give me a round of applause too now. And also Chief Philip Ume SAN. He has also agreed to host the program. It is not a financially intensive program. You are expected to host in your office. Don't go and rent. And you can have facilitators from your office who have knowledge to share about insolvency practice to the people who attend. You can also have people, non-insolvency practitioners, because we want to teach people soft skills too. You have to know how to engage in negotiations, because it's not all about a formal court process. You have to have the ability to engage. So many different things that we will learn in this kind of interactive sessions. So once again, I congratulate our debaters today for the job well done. I will invite past President Seyi Akinwumi to please come and present their plaques to the chairman and the debaters. Thank you very much.
Well, I think it's all been said about this debate. And the one thing that I found very interesting was the comeback. The initial debates were good, but, you know, hearing the other side and thinking on your feet, I think is the most important thing today. And for me, I think both of you won. So, and BRIPAN has won. So, well done. Yes, the one thing here, of course, is that, you know, this gala night we have this evening, we already have one artist. So it's a good enough reason to come back. But really well done. The improvisation.
Distinguished delegates, we are still open for more volunteer firms and individuals who are interested in hosting our BRIPAN member mentorship future leaders group. So please feel free to contact me or contact the chairman or the chairperson of the group if you are interested in hosting us or sponsoring the program. Thank you very much. Thank you very much. I think maybe I should wait here. I would get some sponsors. Pidabo, I think you already agreed to sponsor. I think I forgot to mention your name. Sorry, Pidabo. Jackson, Eti, and Edu have agreed to. Please give them a round of applause. Prince Asama Kadiri Esied. Akinwumi Ambusari, Mr. Sheyi Akinwumi, past president. Thank you very much. I hope you are writing it down, their names down. Hey, Pinero LP, Kemi Pinero SAN, Dr. Kemi Pinero SAN, thank you very much. Yes, any other sponsors? I have already directed my past president, my immediate past president. Salute, sir. Much respect, sir. I'm the one that is now giving presidential order on the past president. Thank you very much, Professor Fidelis Odita, King's Counsel, Senior Advocate of Nigeria. So, I think that's the end of this. Okay, all right. Just before I hand the microphone back to the MC, I just want to remind us about what we have lined up for this evening. What do we have lined up for this evening? I can't hear you. From that corner, please, what do we have lined up for this evening? You can see. You can see. This alone should interest you. This alone should interest you. 70 inches. I want to urge you, don't miss the gala night. And it is the theme is Africa Futurism. And we want you to come in your native attires. You will see me. I'm from Ondo town. You will see that Ondo people, we sabi dress well. I'm coming in my full Ondo with my inyo. You will know what inyo is today. So I urge you all to please come attend the gala night and prepare to enjoy yourselves. It's a long weekend. It's a long weekend, plenty to eat and drink. And our DJ is one of the leading DJs in the continent. And be rest assured of our MC. You are seeing her like this. Wait until evening time, and you know she's bad like that.
Thank you so much, sir. Ladies and gentlemen, please put your hands together for Mr. President. All right, I don't think anything much more needs to be said. You know that we have to be back here later in the evening. But in the meantime, lunch is served. So we'll make it really quick. We have 2 serving points. All right, we'll call out your tables and you quickly go to the 7 point. May we have table 1 and table 2? Please go this way, sirs. Let's have table 3 and 4 over at the one towards the back end of the hall. May I have light music in the background? Or party music so that we'll begin to get a feel of what it's going to be like later in the night. Table 1 and 2 this way, 3 and 4 that way. Thank you. May I have the ushers on standby to help us with this process?
I was born to be free.
Somto, if you have like a Nigerian playlist on your phone, it won't be bad. Thank you. Also an Oibo house party. Remember, there'll be comedy, music, lots to eat and drink at the gala night. It's the party after the party. May I have table 5? Please come over to this 7 point. Table 5. Table 5. This way, please. Table 6. Table 6. This way, please. May I have table 7 over at that 7 point? Thank you. May I have table 11 this way, please?
When I land, you go see commando.